Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
She did not fill out a PD application. She wasn't able to.
All right. Ms. Curry, I've reviewed a probable cause charging affidavit that charges you with trespass on property. I do find probable cause. I'll provisionally appoint the Office of the Public Defender to represent you in the matter. Give me a moment. All right. Looks like she was out on pretrial release, ROR, in 2022 CF 198 for battery on a law enforcement officer before Judge Karsten. I do not know whether or not there is any competency findings in any of her previous cases to include this one, 2022 CF 198. However, I will revoke her release status in that case and hold her without bond pending review by Judge Karsten. Is there anything further from the state?
No, Your Honor.
And I will stay the bonds. Thank you for that. It's $500 on the trespass, which is stayed. And you said she's got a VOP. I don't have the paperwork.
VOP.
Maybe it's just the one. Yeah. All right. I thought it was her. Okay. All right. Thank you, ma'am. All right, anybody else you need called out of order, other than the interpreter?
Your Honor, I'm having a hard time hearing you. Are you asking me about the case for the interpreter?
No, is there anyone else you need called out of order?
No, Your Honor.
All right. So next up, I have Donald Camp. Donald Camp.
Your Honor, Mr. Camp was adjudicated ICP, the Honorable Judge Young, on January 19th, 2022, dismissed 21 CF 2421.
All right, I'm well familiar with Mr. Camp from my time down in Osceola County. Mr. Camp, how are you?
How you doing? Thank you.
Good. Mr. Camp, I have reviewed a probable cause charging affidavit that charges you with petty theft with 2 or more prior theft convictions. I do find probable cause. I do note that you've been found permanently incompetent, and the last finding, according to the face sheet that I'm looking at, was on 1/19/2022. Now, with regard to mental health PTR, does that exist in Osceola County?
It does exist. However, Mr. Camp does not qualify at this time due to a history of noncompliance with previous PTRs.
All right, Mr. Camp, I've told you things in the past, and I'm going to say this to you again, sir. You cannot continue to go out into the community and get arrested for alleged crimes. I don't want you returning to any Dollar General. I'm going to release you on your own recognizance, but I do not want you returning to any Dollar General. I am appointing the Office of the Public Defender to represent you. Ma'am, I want you to get some contact information from Mr. Camp. I realize that he is transient, according to what I'm reading. But Mr. Camp, do you have a telephone?
I ain't got no telephone, no ma'am.
All right, so I want you to give the telephone number that you have to the public defender if you haven't already, okay?
Yes, sir. Thank you.
All right. Conditions of your release, again, are that you not return to any Dollar General.
Sure, I won't. Thank you.
All right. Next up, I have Felix Colon Diaz. Good morning, sir.
Good morning. I don't speak English.
You're confused? Is that what you said?
I don't speak English.
I'm sorry. You don't speak English?
Interpreter, Your
All
Honor.
right. This is the Spanish interpreter. We'll call him at the end. If you could have a seat again, sir. Brian Frazier. Good morning, sir. Please state your name.
Brian Eugene Frazier.
All right. Mr. Frazier, you detained on a felony warrant issued by the Honorable John Morgan. There is no bond. It's based on a violation of probation or community control. Bond will be stayed at none. I will appoint the Office of the Public Defender to represent you in the matter. Anything further from the defense?
Nothing from the defense, Your Honor.
State?
Nothing from the state.
All right. Thank you, sir. Nancy Garcia. Good morning, ma'am. Please state your name.
Nancy Garcia.
Ma'am, I reviewed a probable cause charging affidavit that charges you with battery, domestic violence. I do find probable cause. Going to set bond in the sum of $500 plus release to pretrial release. PTR, is there any criminal history here?
She has no Florida priors. She has 2 out of Georgia, both of which were no valid driver's license, and that was 2014 and 2021. We did have contact with the alleged victim, and he would like to have contact.
All right, ma'am, I'm going to allow non-hostile contact. Do you have any place to stay other than the address on 305 East Tropicana Court in Kissimmee?
Yes, I do.
All right. I want you to maintain separate residences. No hostile contact means no yelling, no screaming, no punching, no kicking. All right. I will appoint the Office of the Public Defender to represent you in the matter. With respect to pretrial release, please follow all of their rules and regulations, okay?
Okay, thank you.
All right, thank you. Brandon Holder.
Your Honor, Mr. Holder bonded out.
All right, Mr. Holder bonded. Stephanie McCord. Ma'am, state your name.
Stephanie McCord.
Ma'am, I reviewed a probable cause charging affidavit that charges you with battery, domestic violence. I do find probable cause. I will appoint the Office of the Public Defender to represent you in the matter. PTR, does she have any prior history?
She does have old history between the years 2010 and 2019. She does have prior batteries, no convictions on those batteries, and unknown if it's the same victim. We did have contact with this alleged victim, and he is requesting contact.
All right. Ma'am, I will set bond in the sum of $500. I will also release you to pretrial release. You will have no hostile contact with the victim in the matter. That means no yelling, no screaming, no punching, no yelling. I will require, though, that you have separate residences. As I indicated, I appointed the Office of the Public Defender to represent you. Thank you, ma'am.
Thank you.
Bryson McPherson. Sir, you Bryson McPherson?
Yes, ma'am.
All right, sir, you were detained on an out-of-county warrant, no bond warrant, and it looks like it was for a violation of probation. The issuing magistrate set bond at none. Bond will be stayed at none. Polk County should come to get you within the next 24 hours. If they do not, notify the jail staff, okay? Thank you, sir. Joshua Palinkas.
Good morning, Your Honor.
Good morning, sir. All right, so I reviewed a probable cause charging affidavit that charges you with written threats to kill or do bodily harm, domestic violence. I do find probable cause. I will appoint the Office of the Public Defender to represent you in the matter. PTR, does he have any prior history?
He had battery domestic in 2018, which was dropped, and an aggravated battery on a person 65 years of age or older in 2019, also dropped. No convictions.
All right. Sir, I will set bond in this, like I said, in the sum of $500 plus pretrial release. You will not have any contact whatsoever with the victim in the matter, that is directly or indirectly. You will not come within 500 feet of the victim's residence, employment, vehicle.
We live together, and we.
I'm getting that. I'm getting that. All right, you also have a child together, correct?
Yeah.
All right. But I have to take this matter very seriously, sir, and I do take it very seriously. So this is something that you can always seek to modify in the future. I will allow telephonic, not text. Well, actually, I take that back. I'll allow text contact only with regard to your child and no other subject.
Okay.
And that means you will not be discussing this case with her or anything other than the child. I will appoint the Office of the Public Defender if I have not already done so. All right, thank you, sir.
And Your Honor, for clarification, the conditions were separate residence?
Maintain separate residence. Do not come within 500 feet of the victim's residence, vehicle, or employment. They can have text contact only with respect to the minor child.
Thank you.
Text contact, yeah, text contact only. Or you could just say text contact only with the victim.
I still mark no contact, but I also put in.
Okay. Jamiah Pemberton.
Good morning.
Good morning. Ma'am, I've reviewed a probable cause charging affidavit that charges you with a battery, domestic violence, and I will find probable cause. I will appoint the Office of the Public Defender to represent you. Apparently, you're currently on probation in the juvenile court system in case number 2018 CJ 726 for battery on a person 65 years of age or older and battery domestic violence. With regard to that, I will find that you have violated the terms of your probation, or find that there's probable cause to believe you've violated the terms of your probation in that juvenile case number. However, I'm going to take no action in the juvenile case number. And other than the juvenile battery on a person 65 years of age or older, what is her prior history of PTR?
Yes, Your Honor, she has multiple priors between the years 2015 and 2020, all as a juvenile, all of them of a violent nature. She has 11 prior battery domestics, 2 aggravated assaults, and 1 battery on a 65-year or older between those years. We did have contact with the alleged victim, who is the mother, and the mother is requesting contact.
Right. All right. And Ms. Pemberton,
Yes, ma'am.
where are you going to live?
I have family members that I could live with.
Okay. All right, so I am going to appoint the Office of the Public Defender to represent you. I'm going to set bond in the sum of $500. You don't qualify for pretrial release because you're currently on juvenile probation. However, the conditions of your release will be as follows. You will not return or come within 500 feet of the address of your mother. It's listed here as 130 Pansy Court. Is that correct?
Yes, ma'am.
All right, you will not have any contact whatsoever with your mother, and that's notwithstanding the fact that she wants to have contact with you. I'm not going to allow that. No contact directly or indirectly.
Yes, ma'am.
And I want you to report to your juvenile probation officer within 24 business hours of your release. Do you understand all that?
Yes, ma'am.
All right. Anything further from the defense or the state?
Nothing from the defense, Your Honor.
Nothing from the state.
No, I didn't say that to her. This one's no return to the residence, ma'am.
Yes, ma'am.
Okay. I did.
Yeah,
All right, within 500 feet of the residence, yeah.
so just say do not return to the.
Just do not return is fine in this case.
And then report to juvenile.
Put to juvenile probation officer within 24 business hours of release. All right, Paul Weldon. You Paul Weldon?
Yes, ma'am.
Thank you. All right, sir, I have reviewed a probable cause charging affidavit that charges you with battery domestic violence, and I do find probable cause. PTR, does, and I'll appoint the Office of the Public Defender to represent you. Does he have any prior history?
He has a 2007 battery domestic, which was dropped, a 2013 non-domestic battery, also dropped, and out of Tennessee in 1999, an ag assault, also dropped, no convictions.
All right, the ones here in this state, do you know if they are the same listed victim or different?
Not the same victim.
Okay. All right, sir, I am going to set bond in the sum of $500. I require that you have no contact whatsoever with the victim in the matter. You will not return or come within 500 feet of the listed address. And with respect to this, sir, I'm going to require also that you not be in possession of any firearms or ammunition. And maintain separate residence.
Your Honor, is this with PTR?
Let's see. Yes, he does qualify for PTR, so that is with pretrial release conditions as well. Sir, do you need a one-time assist to retrieve your personal effects?
Yes, ma'am. There's also 3 kids. Is there any text available or anything?
All right, sir, I will allow text contact only on that subject and that subject alone, your children. You are not to be communicating with her through text with regard to this case or anything other than the children. Do you understand that?
Yes, ma'am.
All right.
And
And that is non-hostile. That means there won't be any use of explicatives or any, cussing or any threats or anything through the text. Do you understand that?
Yes, ma'am.
So you want to take off the no
And that
contact
is with the one-time return?
Hang on one second.
So do you want to take off the no contact and put no hostile, or you want to keep the no contact?
No, just put no contact with the exception of text messages only about the children. And I'm sorry, what did you say, defense?
I'm just, for clarification, that is with the one-time return with law enforcement?
Yes. You'll be able to return with law enforcement one time, and that's with law enforcement to pick up personal effects. Anything further?
Nothing from the defense, Your Honor.
All right, thank you. Gilberto Rivera Resto.
Your Honor, he's still detoxing as he was yesterday.
All right, so we'll reset him till tomorrow. Sarah Nicole Schaefer. Good morning, ma'am.
Good morning, Your Honor.
State your name.
Sarah Schaefer.
All right, ma'am, I reviewed a probable cause charging affidavit that charges you with battery domestic violence. I do find probable cause. UTR, does she qualify?
Yes, Your Honor. For the record, Ms. Schaefer has no prior arrest. She does qualify for bond with PTR, and we did have contact with the alleged victim who is requesting contact and wants the defendant to return to the home.
Okay. Ma'am, do you have any other place to stay?
No, Your Honor.
I'm going to appoint the Office of the Public Defender to represent you. I'm going to set bond in the sum of $500 with pretrial release with the following conditions. You will submit to biweekly alcohol screenings at your own expense and drug screenings. You will not be in possession of any alcohol. You will not consume any alcohol. You will not visit any places such as bars that sell. You won't visit any bars, okay, that sell alcohol. You may not drink, period. Do you understand that, ma'am?
Yes, ma'am.
That is a condition of your release. If the court finds probable cause to believe that you have been drinking alcohol or using illegal drugs, that means drugs that are not validly and legally prescribed to you by a physician, then the court will not hesitate to revoke your release and place you back in jail on a no bond status. Okay? You may not drink alcohol. You will have no hostile contact with the victim in the matter. That means no yelling, no screaming, no punching, no kicking. You may return to the residence with that understanding. No hostile contact.
Yes, ma'am.
All right. Anything further from the state or the defense?
Nothing from the state.
Nothing from the defense, Your Honor.
All right, thank you. All right, so what I'm going to do is call the last case I have is the interpreter case. And then if we could pull up from Orange County some of the folks needing Spanish interpreters. Call in the interpreter.
Hello, Cisco Unity Connection Messaging System. From a touch-tone telephone, you may dial an extension at any time. For a directory of extensions,
I
press
might
4.
cut off
Otherwise,
out
please
doing
hold to
this.
leave a general message. Sorry, there is no operator available at this hour. Record your message at the tone. When you are finished, hang up or press pound for more options.
All right, let's just wait a moment and we'll recall the interpreter. Maybe they're just busy. All right, we're going to attempt the interpreter one more time. Hello.
Good morning, Your Honor. This is Laura Royo, State Certified Interpreter.
All right, thank you. All right, we have an Osceola case that's needing your services, and then from there, I'm going to have you remain on the line because I will switch from Osceola to Orange County, okay?
Yes, Your Honor.
All right, Madam Interpreter, do you need any information from me other than the defendant's name?
Yes, I would need the case number if you have one.
We don't have a case number yet, as charges have not been filed,
No problem then.
but I
name will be
have a
fine.
police case number to give you if that's of any assistance to you.
No, it's okay, Your Honor. The name will be fine.
All right, this is Felix. Last name Cologne-Diaz.
Yes, Your Honor.
I'm sorry? Madam Interpreter, have you been previously sworn today?
No, Your Honor, I have not.
All right, if you please raise your right hand to be sworn in by Madam Clerk.
Do you swear to translate from Spanish to English, English to Spanish, truthfully in these matters here today?
Yes, Laura Arroyo, State Certified Interpreter.
All right, thank you. All right, Mr. Cologne-Diaz, you're being provided the services of a court-appointed Spanish interpreter. If you do not understand her or hear her at any time, please tell us to stop.
Señor Colón Díaz, se le está proveyendo a usted los servicios de un intérprete en español. Si en algún momento dado no la entiende o no la oye, por favor déjenos saber.
All right, hang on, he can't hear. Madam Interpreter, I've turned the volume up.
Can you hear me, Your Honor?
I can hear you very well, but I think out in Osceola, they can't hear you so well.
I'm so sorry. On my end, there's nothing I can do for the volume control. My understanding is that can be controlled from the courtroom.
I have increased the volume in the courtroom all the way up.
Okay, I will try to speak as loud as I can.
All right, so, sir, you're being provided the services of a court-appointed Spanish interpreter.
Bien, señor, se le está proveyendo a usted los servicios de un intérprete en español.
Can you hear her?
¿Me escucha? Very little.
All right. Is there anything else to your knowledge we can do to rectify the situation? All right. Madam Interpreter, I'm just going to continue to ask you to speak up and go slowly.
Yes, Your Honor.
Sir, I want you to listen very carefully, and if everyone in the jail there could be very quiet, please.
Señor, le voy a pedir a usted que escuche con mucha atención y pido a los demás en la cárcel que por favor guarden silencio.
All right. So you're shaking your head that you understood that? Did you hear her?
Señor, me está haciendo un gesto con la cabeza para indicar que está entendiendo. ¿Me escuchó? Yes, ma'am.
All right, good. Sir, I've reviewed a probable cause charging affidavit.
Señor, he estudiado el affidavit de imputación y determino que existen indicios de criminalidad.
It charges you with domestic violence, battery, and false imprisonment.
Donde se le acusa a usted de agresión física por violencia doméstica y privación de la libertad.
I do find probable cause.
Determino que existe suficiente indicios de criminalidad.
I am going to appoint the Office of the Public Defender to represent you.
Se le designará a las oficinas de defensores públicos para que le representen a usted.
I'm going to set bond in count 1 at $500.
En el primer cargo se fijará la fianza en $500.
Count 2 in $100.
En el segundo, $100.
Total bond is $600.
El monto total será $600.
That is also with conditions of pretrial release.
También será eso con condiciones de libertad provisional.
Sir, I do not want you to have any contact whatsoever with the victim in the case.
Señor, le prohíbo a usted tener ningún tipo de contacto en absoluto con la víctima en la presente causa.
You may not return to the address.
Usted estará prohibido regresar a esa dirección.
Do you have any clothing that you need to retrieve or personal effects?
Señor, ¿le quedan ropa o pertenencias que necesita recoger de ese lugar?
The lady not living here. He moved to Orlando. Me living by so here for 5 years.
Sir, please speak in Spanish so that the interpreter can then interpret that into English.
Señor, le pido que por favor me hable en español para que la intérprete lo traduzca.
ella se fue de la casa, ella se fue para Orlando, porque ella vivía conmigo porque se vino conmigo a vivir, pero yo vivo 5 años ahí.
Yes, she's moved out of the home. She now lives in Orlando. She was living with me because I've been living in that home for 5 years.
All right, thank you, sir. Then I will modify the release to be as follows. You'll maintain a separate residence from her.
Muy bien, se modificará las condiciones de libertad para que sean de la siguiente manera. Usted estará prohibido convivir con ella.
All right, you will not come within 500 feet of her house or her car or her job.
Y prohibido acercarse a menos de 500 pies de la vivienda de ella, del carro de ella o el lugar de empleo de ella.
Do you understand all of that, sir?
¿Todo eso lo ha entendido usted, señor?
Sí, señora.
Yes, ma'am.
All right. Anything further?
Nothing from the state.
All right.
From the defense, Your Honor.
¿Queda algo más? Nada de parte de la Fiscalía ni tampoco de parte de la defensa.
All right, sir. Thank you very much.
Muy bien, señor. Muchas gracias.
Thank you.
All right, I believe that concludes our business in Osceola. Is that correct?
Yes, Your Honor. Thank you.
All right, thank you all.
Please enjoy this pre-COVID bond court session. Starting in 3, 2, 1. Bond court.
Good morning, Honor. My name is Fernando Perez on behalf of the Office of the Public Defender.
All right. The first files I have are James Smith. Your name, sir?
Nathan Smith.
All right, sir, you've got a couple of things here. Burglary of an occupied structure, bond $5,000. Petty theft, bond $250. And another case involving disorderly intoxication, bond $250. So it looks like the total bonds would be $5,500. Now, sir, do you want me to appoint a lawyer for you?
Sure, yes, sir.
The Office of the Public Defender is appointed. Division 10 on the felony case and A on the misdemeanor. Your name, sir?
Yeah, 4 acres.
All right, sir. Let's see. Sir, you have a Volusia County warrant, apparently. Your bond totals $575. Looks like it's a battery charge. You'll be transported, sir, to Volusia County to answer to the charges there. William McLeish.
Yes, sir.
All right, sir, you've got a set of charges here. Retail petty theft, bond $500. Resisting an officer without violence, bond $100. Do you want me to appoint a lawyer for you, sir?
I'm already been appointed.
I couldn't hear you, sir. The
Already
question
been-
is,
already been.
do you want me to appoint a lawyer for you?
I think I already got a public defender.
All right. Public defenders are lawyers. The Office of the Public Defender would be appointed in regard to this case.
Oh, yes, sir. Yes, sir.
So your bonds totals $600.
It is an open case. He's out of on the case.
He's out on bond in this case. You want to take any action on it or no action?
Let's see. It's the same charges, isn't it? Retail theft and resisting without. On that, the new one?
This is petty theft and resisting without. But this is, they didn't print it out for you. Hold on. The other charges are robbery and resisting officer without violence.
All right, the bond on which you are released at this time, not the new case, but the one on which you're released, is revoked. All right, next case is that of Kenneth Hardy. All right, your name, sir?
Kenneth Hardy.
Mr. Hardy, you've got a charge here of disorderly conduct. Your bond at this time is $250. Do you want me to appoint a lawyer for you?
Yes.
Public Defenders appointed, Division A, offer from the state.
One second, Your Honor. Yes, 1 second as well, Your Honor. I don't believe this man was listed in the move-ups. Oh, I'm sorry, I'm looking at felonies, that's silly. There we go. City and county ordinances.
State does not have an offer, Your Honor.
All right. All right, that's it then.
How long am I going to be in here on that?
We have to report to get, so you want to get in touch, that's about that week. So we want, definitely.
I don't have it. The judge, can he give me time served?
All right, the next file is that of looks like Adolfo Salinas Soba Bar. Sir, what is your name, please?
Adolfo Salinas Ovalbarro.
All right. Sir, you've got an open container charge. Do you want me to appoint a lawyer for you?
Yes.
Yes, Your Honor.
All right, public defender's appointed. Offer from the state.
Your Honor, the state has no offer on this case as well.
All right. If a plea of guilty or no contest is entered, the court would sentence this gentleman to 5 days, credit for 2 days, time served, and court costs totaling $273 payable within a year, adjudication of guilt.
Okay.
Is he a brand new state attorney?
My client would like to accept the court's offer at this time and enter a plea of no contest.
All right. There's a factual basis stated here in the arrest affidavit. The plea would be accepted, and that penalty would be imposed, adjudication, and 5 days credit for 2, and the court costs as previously announced. Yeah, you're right.
Three more days? Today?
Yes, sir.
All right, the next file is that of Kenneth Jeter. Is that you, sir?
Kenneth Jeter.
All right. Mr. Jeter, you've got a charge here of trespass on property after warning. Is there any offer from the state on this case?
No, Your Honor.
All right. Office of the Public Defender is appointed to represent you. If a plea were to be entered, there would be an adjudication, 5 days Orange County Jail, credit for 2 days time served, court costs $323 payable within 1 year.
I'm not saying that. I didn't do that. I'm not touching nothing. Simon.
Sir, one moment. Apologies, Your Honor, sir. Your Honor, apologies. Would a possible, apologies, yes. So that's just what we're looking at right now, sir. I'm going to say that. Be here 3 days, sir.
No, I'm letting you go all the time. Let me go. All
All right, if there's no decision by the defendant at this time, we're going to move on.
Okay, good luck, sir. Wait, hold on.
No, he said hold on. He said hold on.
There you go, that's our paperwork.
Your Honor, the bond was set in this case for how much?
Sorry, sir, good luck, sir.
500.
Thank you.
Good luck, sir.
And the PD's appointed, correct?
Yes.
Yes.
Mr. Pemberton. Okay.
Linda Nelson. Your name, please.
Linda Nelson.
All right, Ms. Nelson, you've got a charge of trespass on property after warning. Do you want me to appoint a lawyer for you?
Public defender.
Public defender's appointed, Division A, $500 bond. Now, on this case, is there any input from the state?
Your Honor, the state would be prepared to offer 5 days in jail, no return to the scene, and court costs.
Would the state, wait, no. Would the state be willing to consider a credit time served offer? My client does not seem to have an extensive history, and nor does he seem a particular danger to the community.
How much credit does
2 days.
3 days?
2 days.
2 days.
Well, she's been in here 2 days, right? Okay, she's been in
I
here.
want to plead guilty to the charge.
Your Honor, the state will offer 2 days. We'll do a credit time serve offer.
Kill me out there.
Ma'am, we have an offer from the state. It's adjudication, credit time served. You would get out today.
I don't want to be out there around those people. They out there trying to kill me.
Okay. So you don't want to accept the offer?
No.
Okay.
All right.
There's a $500 bond. Okay, wait, hold on. Let me give her paperwork. There you go. Good luck, ma'am.
Mario Appointe. Right, reset. The next file then is that of Babalu Jakeshan, if I pronounce that correctly.
Jakeshan Babulao.
All right, sir, you have a set of charges here. Burglary of a structure, bond $5,000. Petty theft, bond $100. Criminal mischief, more than $200, less than $1,000, bond $100. and dealing in stolen property, bond $150. Now, sir, do you want me to appoint a lawyer for you?
Yes.
Office of the Public Defender is appointed, Division 17.
Go with that. You do. 5,000, now from a bit, bond like 500.
In total?
No, 500 for the top first one. But good luck, sir.
All right, the next file is that of David Benson. There are two charges here, possession of cocaine and no valid driver's license. Sir, do you want me, are you Mr. Benson?
Yes, sir.
Do you want me to appoint a lawyer for you?
Yes, sir.
Public Defender's appointed, Division 16 on the cocaine case, and Division A on the no valid.
You said Division 80 on no valid?
Say again?
You said Division 80 on no valid?
No, Division A is an apple.
A, thank you.
She qualifies for PTR.
And what are the charges again?
Possession of cocaine and no valid driver's license.
Now, when they qualify for PTR, does the judge always look at that? All right, even though he qualifies for PTR, that qualification will not be considered at this time by the court, so the bonds remain at a total of $1,500.
Your Honor, if the defense may be heard, my client does not have an extensive history, and the facts of the case show it was, by the estimates of the officer, allegedly a small baggie. Would the court be willing to reconsider in light of the fact that my client has no extensive history and the facts of the case don't rise to a level to completely discount PTR?
Well, in regard to the cocaine case, then the court would reduce the bond to $500 as opposed to $1,000, and the other bond remains the same. And that was $500.
Understood.
Okay. All right, Todd Brule?
Yes, sir.
Sir, you have a set of charges here. Battery on a person 65 years of age or older. You're in a no bond status in regard to that. And a charge of simple battery on which the charge is $500 with conditions. No contact directly or indirectly with the victim or co-defendant witnesses, maintain a separate residence, don't return to the scene of the offense, don't possess or consume any alcohol or illegal drugs, don't possess any weapons or firearms. So, sir, do you want me to appoint a lawyer for you?
Yes, please.
All right, Division 19.
Apologies, Your Honor. Did we state the bond as the battery, and did we set no bond as to the battery on of the alleged battery on person of 65 age or older?
Correct.
Thank you, Your Honor, for the clarification. Here. Let's go over here. Your Honor, you can't bond that at the moment. So that's what we're doing right now. I wish you good luck. Please get in touch with us when you can. So, thank you.
All right, next case is that of Kenyon Bryant. What is your name, sir?
Kenyon Bryant.
All right, sir, several things here. A warrant here for robbery by sudden snatching. Your bond there is $5,000. You're released on a possession of cocaine within 1,000 feet of a place of worship, and that bond at this time would be revoked, and I believe that's all. So Division 10 on the new case.
You're on that case, sir. So we're going to see what happens there. But if you have any questions on that, you're going to want to talk with the public defender that you assigned. So they may have no bond. Yes, at the moment you can't bond out. So you're going to get in touch with our office when you can. This is going to be an ongoing matter. I want to wish you good luck. Thank you.
All right, your name, sir?
Isaiah Cordero.
Mr. Cordero, sir, you've got a warrant here that was issued for failure to appear on possession of methamphetamine, possession of 20 grams or less of cannabis, and possession of drug paraphernalia. And it states here you failed to appear, so you're in a no bond status. Now, do you want me to appoint a lawyer? Was the public defender previously appointed?
Yeah, that public defender.
All right, public defender is appointed, if not reappointed, Division 16.
That may not be an immediate excuse upon the jurisdiction. So we're going to you're going to get to us. Because if that is not good, then I was incarcerated when I wanted that to happen. Okay. Thank you.
All right, next file is that of Kareem Ford.
Yes, sir.
All right, sir, two things here. Failure to appear capious on a delivery of cocaine case. You're in a no bond status in regard to that. And then, let's see. Yes, looks like you got another case from 2012, failure to appear. Both of these are Division 14. Appears to be two separate cases, two separate differing case numbers. Sir, was the public defender previously appointed?
Yes.
Yes, yes, sir.
All right. That's Division 14 on both. All right, the next file is that of Joseph Hill. Is that you, sir?
Yes, sir.
All right, Mr. Hill. Sir, you've got a charge of possession of cocaine on which your bond is $1,000. I don't have any financial affidavit filled out for you. Does the public defender know if you've had prior representation?
I do not know at this time, Your Honor. Not in this current case. I do not believe he has a public defender assigned to this case.
Well, let's see. Mr. Hill, are you intending to hire an attorney?
No.
Do you want me to consider appointing the office of the public defender at this time?
Correct.
All right, public defender is appointed, Division 12.
Which one would file for PTR?
All right, so ordered.
Call what number?
This one.
Today?
Judge. Just straight.
Yes.
Qualifies for PTR.
Yes.
Okay.
Granted?
Okay.
All right,
Okay.
Michael Hoyman is the next case. Is that you, sir?
Yes, sir.
All right, sir, a set of charges here. Burglary of a structure, bond $3,500. Grand theft, third degree, more than $300, less than $5,000, bond $150. Dealing in stolen property, bond $150. Receiving money from a pawnbroker with false verification, bond $150. And criminal mischief, more than $200, less than $1,000, bond is $100. Now, sir, do you want me to appoint a lawyer for you?
Yes.
Office of the Public Defender is appointed, Division 14.
We're currently, yes, looking at, I believe the, just about all the documents. That's right. Now, I have an appointment with the defender, that's good. I have on all of these. That's what I do. We have a president, I have a officer, I can do that. It's very awesome.
All right.
I don't know if you'd like, sir.
Bless you. All right, next file is that of Mark Jokin.
He bought it, Your Honor.
All right. Then Ronald Meekins.
Yes, sir.
All right, sir, a set of charges here. Petty theft with 2 prior convictions, 2 counts of that. Your bond is $1,000, count 1, $150, count 2. Do you want me to appoint a lawyer for you, sir?
Public defender, sir.
Say again?
Public defender.
All right, Office of the Public Defender is appointed, that's Division 12.
So this is kind of an online matter. What we're looking at is, yes, we weren't going to come on down.
Wayne Malier is behavior. Malier.
Say again?
Wayne Malier is behavior.
All right, reset. All right, next file I have then is that of James Miller. Is that you, sir?
Yes, it is.
All right, sir, 3 cases apparently. Retail theft, bond $2,500. Resisting a merchant, bond $100. And then another case of retail theft, more than $300. Your bond is $1,000 in regard to that allegation. And lastly, another retail theft, more than $300, bond $1,000. Now, sir, do you want me to appoint a lawyer for you?
Yes.
All right, we have Division 15, the public defender's appointed. Division 15, first case. Division 11, second case, and 15 again on the third case. Next file I have is that of Kevin Morris.
Yes, Your Honor.
All right, Mr. Morris, you've got a set of charges here. Possession of heroin, bond $1,000, and possession of paraphernalia, bond $500. Do you want me to appoint a lawyer for you, sir?
Public defender, Your Honor. I believe I signed up for one already today also.
All right, the Office of the Public Defender is hereby appointed on these charges. That's Division 19.
He qualifies for PTR.
What do other judges deny PTR if they qualify? All right, bond or PTR on that case. Yes.
No, you're not RR. You just get out of bond without having paid bond. But it's still not the case. The cause that he can.
All right, next file is that of Lentice Owens.
Yes, yes.
All right, sir, you've got a charge here of failure to report name or residence change as a sex offender. And at this time, you're in a no bond status. Do you want me to appoint a lawyer for you, sir?
He's asking if you want a public defender.
Office of the Public Defender is appointed Division 15. All right, the next file is that of Anthony.
Apologies, a moment to confer with records. Oh, yes. Apologies, Your Honor. Apparently my client does qualify for bond status. Would it be possible, considering he does not have an extensive history, if he could receive a bond today?
That what?
The failure to report cases, they usually get a
All right. Well, I'm going to then set a bond at this time in the amount of $2,500.
Your Honor, the state asks that the bond be set at 5,000.
Let me look here. All right, having scanned the paperwork once again, the state's request to be granted be the higher amount, 1,000 or whatever. 5,000. All right, now the next file is that of Anthony Parton. Is that you, sir?
Yes, sir.
All right, sir. Several counts here, charges. Carrying a concealed weapon by a convicted felon, bond $5,000. And then possession of a firearm by a convicted felon, bond $150. And then looks like 5 counts of possession of ammunition by a convicted felon, bond $150 on each of those 5 counts. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
Office of the Public Defender is appointed, Division 22. All right, next file I have is that of Dion Richardson.
Apologies, Your Honor, I'm still getting my, Your Honor, may I have a moment to make a quick call to office? I appear to be running low on paperwork, and I need them to send a paralegal down with replacements.
All right.
Apologies. Just a moment to return to my desk. Actually, on second thought, Your Honor, let's do Mr. Richardson, and then I need to head upstairs for a brief 2-minute, a brief 2-minute absence to retrieve more paperwork. I apologize. There was a lapse in my office's workings. So,
what's the total amount of time you're requesting?
2 minutes.
What?
Or 1 moment, actually. If I may confer with a colleague of mine. Yes. Hi. Apologies.
What did he say?
It appears that we're able to continue the proceedings.
All right. Then we will proceed. The next case is that of Dion Richardson.
Yes, sir.
All right, Mr. Richardson, sir, you've got a charge here of grand theft 3rd degree of a motor vehicle. Bond in your case is $1,000. Do you want me to appoint a lawyer to represent you?
Yes, sir.
All right. Division 15, public defender appointed.
Sir. Am I eligible for I mean, I'm a foot.
All right, next file is that of Emilio Serrano.
Yes, sir.
All right, sir, you've got a set of charges here. Burglary of a conveyance with assault or battery, no bond at this moment. Possession of a firearm in commission of a felony, no bond. Now, I don't have any application for criminal indigent status. Have you been previously represented by the Office of the Public Defender?
I choose go private.
Say again?
I'm gonna get my own attorney.
Oh, you're going to hire your own lawyer?
Yes.
All right. Well, for what it's worth, that's Division 15. All right, that concludes the case then. All right, next file is that of Logan Schumpert. Is that you, sir?
Yes, sir.
All right, sir, a set of charges here. Possession of cocaine, bond $1,000. Possession of drug paraphernalia, bond $500. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Office of the Public Defender is appointed, Division 20.
Records, I see that he didn't qualify for PTR, but the reason was additional notes. Was the detainer was it concerning the DNA retainer, or?
Just wait for the APHIS to be completed, because he was interviewed.
Okay.
Just waiting on the APHIS to be cleared.
Okay, so APHIS hasn't arrived yet. All right, let's see here. Unfortunately, there's nothing I can do at this time. Your Honor, my client has nothing in the way of a record. Would some leniency on the first count be possible at this time?
All right, what's the state's position, if any?
Your Honor, the state will leave it to your discretion.
All right. The bond on count 2 would be reduced to $100 from $500. Count 1 remains the same.
Thank you, Your Honor.
All right, the next file is that of James Starnes. All right, your name, please.
James Starnes, sir.
Mr. Starnes, you've got a charge here, failure to report name or residence change as a sex offender. The bond was set at $10,000 by the judge. Do you want me to appoint a lawyer for you, sir?
Yes, sir, if you would, please.
All right, Office of the Public Defender is hereby appointed. Division 16.
All right.
Okay.
When the defendant doesn't fill out the financial affidavit, the judge's appointed the public defender. All right, the next file is that of Justin Upton. Say again? All right, reset. All right, next case is that of Alan Waters.
TJ, sir, is my first name.
All right, T.J. Allen Waters, right?
Yes, sir. Good morning.
Okay, sir. All right, you've got a set of charges here: fleeing, attempting to elude a police officer, and driving while license suspended. Now, as to count one, you had been you did have that bond. It was originally set at no bond. At this time, the court is setting the bond at $10,000. As to count two, driving while license suspended, that bond is, instead of $2,500, is reduced to $250. Do you want me to appoint a lawyer for you, sir?
Please, sir.
All right, public defenders appointed, Division 22. All right, the next file I have is that of Jeffrey Ragg.
Yes, sir.
Sir, looks like a set. No, here. All right, you're out on bond on a charge of driving while license suspended or revoked with knowledge, second conviction. You have a new case here, bond of $2,500 on driving while license revoked as habitual offender.
Yes, sir.
So, looking at the history here, the bond on which you are released is revoked, and the new bond is the $2,500. Do you want me to appoint a lawyer, sir?
Yes, do that mean I can bond out today?
All right, that's Division 11.
So the original bond, $2,500 on the one you revoked, is the $2,500 too, or no bond? On the one you revoked?
The new case is $2,500. The old one is revoked.
All right, we'll have to see about that. Don't worry. So call us when you can about that. This is an ongoing case as well, so good luck. Okay. Bonding for driving license is revoked. Since you're already out on bond, exactly, it's revoked. So that means you can't bond out just yet. All right. Good luck, sir.
All right, next files are that of Bobby Wyrick.
Yes, sir.
Is that you, sir?
Yes, Your Honor.
All right, just a second. All right, Mr. Wyrick, three cases looks like. Grand theft, third degree of motor vehicle, bond $1,000. Resisting an officer without violence, bond $100. Then another case of failure to appear, and the judge in that case set you at a $500 bond. And then another failure to appear, and that bond likewise is set at $500. So we have $1,000, $100, $500 and $500. Now, sir, do you want me to appoint a lawyer for you, or do you already have a lawyer?
I would like for you to appoint me one, sir.
All right. Public defender appointed, Division 17 on the grand theft, et cetera. Division 85 on the first failure to appear, and 61 on the second failure to appear. All right, next file I have is that of Michael Briggs.
Yes, sir.
Sir, you've got a charge of open container. Bond is $250. I don't have any request for a lawyer from you. Is there any offer from the state on this case?
No, Your Honor.
All right, in regard to this, sir, if you wish to enter a plea of guilty or no contest, you'd be giving up, of course, your right to a trial, but the court would adjudicate you guilty, sentence you to 2 days with credit for 2 days time served, impose court costs, $223 payable within 1 year. You don't have to accept that offer. You may if you want.
I accept that, sir.
All right, so ordered. And I believe that's all then.
Yes, sir. Thank you, sir.
Was a public defender assigned to Mr. Briggs' case?
No, didn't fill out the request. All right, Paul Clark.
Behavior, Your Honor.
All right, reset.
Behavior reset?
Mel Dawson, or
Yes, sir.
Dawson? Is that you, sir?
Yes, sir.
All right, sir, you have a case here involving an allegation of disorderly conduct. Bond is $250. Do you want me to appoint a lawyer for you? All right, public defender is appointed, Division A. Now, in regard to this case, is there an offer from the state?
No, Your Honor.
All right. And what plea would be entered by the defense at this time?
Your Honor, my client does not have a very large history. I think for this particular charge, an adjudication with 2 days going towards a 5 days sentence would be more than sufficient to see justice done on this issue.
All right. If a plea of guilty or no contest were to be entered, the court would impose an adjudication, 3 days, credit for 2 days, time served, and court costs payable within 1 year.
Okay, so,
273.
sorry, you did not say who you were running for. Say who you're running for. Apologies, Your Honor. It appears that something has come up. The defense would like to thank Your Honor for the 5-day offer. But it appears that my client is trying to make a job interview in the morning, not to push matters further. Would a possible CTS be possible in this case, or would Your Honor rather stick with the original offer, which the defense would accept if it were?
All right, I'm sorry, the copier's going, I can't hear you. Speak up or yell or something.
There are important life circumstances for my client tomorrow morning. I was only just made aware of. The defense, therefore, while thankful for the judge's offer, would like to ask if a possible CTS was issuable. If not, the offer as stands by the judge would be acceptable.
All right. What did he say? Did you hear?
Oh, okay, I'm sorry. 3 days.
Yes, sir.
All right. Apologies, Your Honor. It was a miscommunication.
Yes, sir. Yes, sir.
He's gonna take off.
I'm not.
2 days, 3 days. Yeah, you get out of there, because you don't get 2 days. I thought it was 5 days. Yes. He does. Apologies for the misunderstanding, Your Honor. One moment.
Offer 3 days.
3 days, 2 days served.
AG court costs.
AG court costs. All right. Payable. Yes, and it's today. All right. Good luck, sir. Thank you. Yes.
All right, the next file is that of Darnita Carter.
Yes.
Ma'am, you have a set of charges here. Possession of paraphernalia, bond $500. Loitering or prowling, bond $100. Securing another for prostitution, bond $100. So the total bonds are $700. Do you want me to appoint a lawyer for you?
Yes.
All right. Office of the Public Defender is appointed. That's Division A.
I do not qualify for PPR at this time. All right, so given the attorney on this case, you're on my when you can. You may not pay the bond, that may be the case. So anything with relation at this time, there's not much else that can be done. I want to.
All right, next file is that of Damian Jones. Is that you, sir? Sir, you have a set of charges here. Simple battery, bond $100. Resisting an officer without violence, 2 counts of that. $500 on one, $100 on the other for bond. Trespass on school grounds or facility, bond $100. And another case involving simple trespass, bond $100. Now, sir, do you want me to appoint a lawyer for you?
No, sir.
Office of the Public Defender is appointed. Now, let me add one other thing, and that is that you're out on bond on a petty theft and resisting without, and you were ROR'd. That ROR will stay just as it is. All right, now, so the Office of the Public Defender is appointed, and Division A.
Good luck.
All right, next file is that of Dennis Molenda. Is that you, sir?
Yes.
Mr. Molenda, you have a set of charges: petty theft, bond $100, trespass on property after warning, bond $500. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
All right, Public Defender is appointed, Division A. All right, the next file is that,
Your Honor, apologies. I forgot to inquire if the state had an offer on this case.
No, the state does not have an offer because I do not have the history, and petty theft is an enhanceable crime.
I have the history right here if you would like me to give it to you. Permission to approach the state, Your Honor.
Yeah, all right, yeah, the state would not be prepared to make an offer on this case.
okay,
That's our number. Please call me.
okay.
I want to wish you good luck.
All right, then that's all for the moment. Michael Silver,
Yes, sir.
is that you, sir?
Yes, sir.
All right, sir, you're released on a bond on a drug case. That bond is stayed. New cases or allegations: trespass in a conveyance, bond $100; resisting an officer without violence, bond $500. You want me to appoint a lawyer for you, sir?
Yes, sir.
Public Defender is appointed, Division A.
Did we take any action on
No, stay.
it? Stay.
Apologies, Your Honor. I forgot to write down for the benefit of my client. Was the bond in the first appearance detainer or matter thereof revoked or?
What do you want?
No. Okay, no action on the first appearance detainer. Apologies. Thank you, Your Honor.
All right.
All right. Should I take the paperwork, sir? I want to wish you good luck. Please pause when you. You got a bond. You don't have to. Okay, this was stayed. No action. You have a bond there and a bond there. 100, 500. You can bond out, sir. Good luck, sir.
All right, next file I have is that of Rosalind Smith. Is that you, ma'am?
Yes.
Ms. Smith, you've got a charge here of trespass in a conveyance. Your bond is $500. Do you want me to appoint a lawyer for you?
I wasn't sure if I needed one or not, but I said yes.
Well, the Office of the Public Defender would be appointed Division A, and that will do it for the moment. All right. So ordered. All right, next file I have is that of Wally St. Julian.
Yes, sir.
Sir, you've got a St. Lucie County case here, and let's see, failure to appear, and you're in a no bond status right now, so what happens is you would, let me look here. You would be transported to St. Lucie County to answer to the charges there.
You mind repeating that for me one more time, please?
All right, the only files I have left are the 33-day motions. Say again?
Bond hearings, you have some bond hearings in there.
Ah, all right. Motion for release of defendant on ROR, parentheses, 33-day motion.
No, that's not him though, that's not the defendant, the guy that's, this is Mr. Gross. Yeah, you got quite a few there listed.
Oh.
I just didn't know what order it was coming out in, so, yeah.
Gross. Two. All right, next files I have here, or rather file, is motion, the 33-day motion on William John Gross, input from the state.
No objection to RR, Your Honor.
All right. So ordered.
It says Vega, doesn't it? Is there something after Vega?
Thank you.
Good morning, Your Honor. Jace Thompson on behalf of the Office of the Public Defender. For the record, I wanted to, if at all possible, address the case of Todd Brule that you heard earlier. And that's case number 19 CF 3467.
He said from earlier.
What's the?
It's Gomez.
Todd Brule, Bruehl.
19 CF, you said?
19 CF 3467.
All right, that was a charge of battery on a person 65 years of age or older, no bond, and battery $500.
Yes, Your Honor. On the no bond, he is actually entitled to a bond under Florida law. The thing about it is this is a domestic violence case, and it was supposed to be heard in courtroom 2 and not courtroom 1. And I would ask for it to be transferred to courtroom 2, Your Honor.
All right, so ordered. And the order, if any, entered by this court in courtroom 1 would be vacated and set aside.
Thank you, Your Honor.
Next, we got regular Gomez.
Your Honor.
All right, now, I've got, looks like 2 cases on Christopher Vega Gomez, cases ending in number 1297 and 1298.
Your Honor, if the defense may be heard at this time, it is the decision of the immediate representative of the Office of Public Defender to withdraw these motions and if to reinstate them then at a later date.
Can you hear what he's saying?
Speaking to the mic, 'cause we can't hear you.
Apologies, Your Honor. As I was saying, it is the decision of the immediate representative of the Office of Public Defender to withdraw the motions put forth before you today on behalf of Mr. Gomez at this time.
All right, so noted, and they're withdrawn. All right, now, I've got another file here. It's Elijah Kraft, case ending number 1739. So, input from the state.
Elijah Craft. 1 second, Your Honor.
I'm sorry, what was the matter? Apologies. What? I only have a motion to withdraw before me. What was the other matter that we're tending to at this moment?
That's a 33-day.
Oh, okay. Actually, Your Honor, before we commence the 33-day motion, I apologize. I must ask to hear a motion to withdraw from the Office of the Public Defender on behalf of one of our clients.
All right.
Let's see here. Would the judge like a copy of this motion presented to you at this time? All right.
All right.
In that case, I'm going to require either the assistance of records to print it out or to, or if you would like to look at it temporarily, I can go over it. All right. Apologies. Here you go.
All right, I assume there's no input from the state?
No, Your Honor.
So ordered, allowing withdrawal.
Thank you, Your Honor.
Next, we have a new,
Please give for determination of counsel on this case.
All right, Ayub Abdulrahman, if I
Yes, sir.
pronounce that correctly.
Oh, you did wonderfully.
All right, now, sir, this is noted as a determination of counsel on a set of charges: arson of a conveyance, possession, manufacturing, transporting a firebomb. And I have now been furnished an application for criminal indigent status. Do you want me to appoint a lawyer for you?
Yes, sir.
All right. Office of the Public Defender would be hereby appointed. You qualify according to the paperwork here. And that's Division 11.
Your Honor, if I may receive clarification, what was the current bond status of the public defender's newest client?
What was the what?
What was the bond status?
5,000, count 1, 150, count 2.
5,150. Okay.
Here for a plea. You can
All right,
just
we're gonna have to see what we
38
can
days.
do, sir. Again, I don't have any cases right now, so I can't get the search. What's your name again? Fernando, but I'll be standing the post here. You'll be one of our guys now. Thank you. All right, good luck, sir. Okay, thank you. Thank you.
All right, I have a file here on Mark Kane, and it states plea that he has 38 days credit, and the input from the public defender.
Was Mr. Kane assigned a public defender for his case?
Look on the second page. Yes. Yes.
Yes. Public defender was appointed by Judge Wish. It was originally disorderly conduct. Has 38 days credit.
I apologize, Your Honor. I don't seem to have his paperwork. Was he a reset?
Hmm?
No, he was an add-on docket.
Oh.
Add-on docket.
I see. Wow. A moment to confer with State. Mr. Barrington, do you have Mr. Kane's complaint sheet on you?
Is it Antonio?
Mark Kane.
Mark Kane. One moment, let me pull up my laptop. All right, actually, apologies. If we may, the account was disorderly conduct originally, right?
Aye.
Yes.
Okay. In that case, if he has been appointed a public defender, then would an adjudication with credit time served be possible at this time if my client were to make a plea to the bench?
This is for disorderly conduct for Mark Kane. We do have an offer. The offer is a withhold, $223 in court, $223 court costs, and a $10 filing fee on the disorderly conduct charge.
The withhold to go to the 13th. Can I tell?
She says I'm PTO.
Good. Apologies for the mix-up, sir. All right, thank you, Mr. Barrington.
The 223s are fine.
My client would like to accept the state's offer at this time and plead no contest.
All right, and for plea purposes only, stipulate to a factual basis. What? Hmm? Is this Kane?
I suppose it's factual basis. I think that's for you.
Yes. Apologies, a moment to confer with state.
All right, there's
Oh, I see, yes, that was the problem. Okay.
notes on the paperwork I have, says plea 38 days.
I see, yes. Plea, motion, 38 days. Okay, yes, I have that now. One moment. Okay. Okay, so we're not stipulating to the factual basis, we just to take the offer from the state. At this time, Your Honor.
Stipulate to the factual basis for the purpose just of the plea.
Okay.
Yeah, just for the purpose of the plea.
Okay. Apologies, Your Honor. We would stipulate to the facts of the case just for the purposes of the plea, Your Honor.
All right. And let's see, for the record, in case it wasn't previously stated, case number 2019 MO 239. And the note, once again on the file, says be a plea with 38 days. And it looks like, let's see, arrest date was February 3rd. So that's at least 38 days, I believe.
Your Honor, and just for record purposes, the offer is a withhold court cost, $10 filing fee, and credit time served for the days that he spent in OCJ.
All right. That guy's name?
Yes, just get in touch with the officer anytime the other matter.
Yeah.
All right, good night, sir. Apologies for the discrepancies, Your Honor.
Let's see. Now, I have another 33-day motion here. Elijah Kraft, case ending in number 1739. State.
Your Honor, denied for Elijah Craft, sent to clerk file. It was sent to clerk filing. ID is 86258948.
All right,
So the state asks that this motion be denied because this case was sent to the clerk, and the filing ID is 86258948.
all right. So ordered, denied.
That's the rest of them.
So all of these are.
All three. Yeah.
All right, now I've got a pile of 33-day motions here. Ryan Beamer, 18, CF 18342.
Your Honor, the state is also asking that this motion be denied. It was filed 3/12. It was filed yesterday, Your Honor.
All right, so ordered. Then another case here, Christian Cutright, case ending in number 1208.
Your Honor, the state is also asking that this motion be denied. It was filed in the filing ID. It was filed yesterday. The filing ID is 86238102.
All right. Next file is that of Lawrence Johnson, case ending in number 1161.
Your Honor, the state is also asking that this motion be denied. It was filed yesterday. The filing ID is 86254763.
All right. Sarah Alicia, case ending in number 1899.
Your Honor, the state is asking that this motion be denied as well. The info was filed on 3/11. Request for administrative transfer filed. Copies provided.
All right, so ordered. Elijah Kraft, case ending in number 16857.
Your Honor, the state is also asking that this motion be denied. It was filed yesterday. Sent to the clerk. The filing ID is 86258948.
All right, so ordered. Molly Fondario.
One moment, Your Honor. I think defense counsel has one.
Request from defense, I'm trying to write down the IDs for paperwork purposes back at the office. Could you read the IDs a bit more slowly
All right, that's fine.
for all denials?
All right.
Now, the next case I have is that of Molly Fondario, case ending in number 2001.
Your Honor, the state is asking that this motion be granted. It was sent to the clerk. The filing ID is 86240999. Yeah, that's it for that one.
So I want to make sure I understand. You're requesting the court grant or deny?
Granted, there was a notice of non-filing sent to the
Okay,
clerk.
all right, good enough.
Yeah, that was a mess up, Your Honor. I'm sorry.
All right, Karen Utter, case ending in number 1836.
Your Honor, the state is asking that this motion be granted. There was a notice of non-filing sent to the clerk yesterday. The
All
filing
right.
ID is 862777806.
All right, so ordered. Molly Fondario, case ending in number 2002.
All right, Your Honor, the state is also asking that this motion be granted. There's a notice of non-filing yesterday on
All right.
3/12.
Daquan Walker, case ending in number 2009.
Your Honor, the state is asking that this motion be granted. There was a notice of non-filing yesterday as well.
So ordered. All right, McHenry Francois, case ending number 1973.
Your Honor, the state is asking that this motion be denied. Yesterday, there was a request for administrative transfer filed.
All right, so ordered. Rachel Brown, case ending in number 18004.
Your Honor, the state is asking that this motion be denied. This case was filed yesterday. The filing ID is 862729991.
All right. Brandon? All right. Now, we're going to take a recess. How long does the public defender request?
All my cases have already been completed. I don't believe there's anything complicated coming up. 35 minutes, if possible, for staff to prepare our clients.
35 minutes?
Yes, Your Honor.
All right. 35 minutes it is by my watch. That would be 20 after 11. But,
Let's make it 11:30, please.
all right, Madam Clerk, she wants to make it 11:30, so 11:30 it will be.
Thank you, Your Honor.
Court's in recess till then. All right, your name, please?
Tasharia Adderley.
Ms. Adderley, you've got a charge here of obtaining controlled substance by forgery. Your bond at this time is $1,000. Now, do you want me to appoint a lawyer for you?
Yes.
All right, Office of the Public Defender is hereby appointed, and that is Division 11.
Your Honor, if the defense may be heard before proceeding, my client, Ms. Adderley, has nothing in the way of a track record. Would it be possible to reduce her bond at this time?
All right, let me review this again. The state have any position in regard to that?
Your Honor, the state will leave it to your discretion.
All right, in regard to this, according to the arrest affidavit, this is one of a number of similar events. So the court feels it would be appropriate to leave the bond as was announced. All right, your name, sir?
Alvarez Perez.
All right, sir, you've got a capias here for a set of charges, failure to appear, no bond, and 2 other failures to appear, no bond. So the judge on that case entered that order. Now,
PD was previously appointed.
all right, public defender was previously appointed, Division 16. All right, next file is that of Jonathan Black. Is that you, sir?
Yes, Your Honor.
All right, sir, you've got a couple of cases here. Purchase of cocaine, bond 1,000. Possession of cocaine within 1,000 feet of a bus stop, bond 500. Tampering with physical evidence, bond 500. Possession of drug paraphernalia, bond $250. And you have yet a second charge, possession of alprazolam, bond $1,000. Now, sir, do you want me to appoint a lawyer for you?
Please.
All right, sir. In regard to the first set of allegations, cocaine, et cetera, that's Division 11. And alprazolam is Division 16.
Okay.
Okay, sir.
Thank you.
Good luck, sir. Call that number when you can.
All right, Horatio Brock.
It's Orisha Brooks.
There was a typo, Your Honor.
It was messed up.
All right. I did not understand what the individual said. What is your name?
My name is Orisha Brooks.
Okay, Brooks. All right, ma'am, you've got a charge here, attempted aggravated battery with a deadly weapon. And in regard to this charge, do you want me to appoint a lawyer to represent you?
Yes.
All right, the Office of the Public Defender is hereby appointed. That's Division 12.
Yes. Good luck, ma'am. Yes, sort of.
All right, the next file is that of Cosby Daniels. Is that you, sir?
Yes, sir.
All right, sir. You've got a set of new charges here. Count 1, possession of firearm by convicted felon. Count 2, possession of ammunition by convicted felon. The first count is $4,000 bond. Second is $150. Possession of oxycodone, bond $150. Possession of alprazolam, bond $150. Possession of tetracannabinoids or something like that, bond $150. Possession of cannabis, bond $100. Possession of paraphernalia, bond $100. Now, in regard to this new case here, do you want me to appoint a lawyer for you, sir?
Yes, sir.
All right, the Office of the Public Defender is hereby appointed. Need to look at one other thing here. All right, now, you're out on bond on possession of firearm by convicted felon, et cetera. And that bond, because of the new charges, is hereby revoked. And public defender is appointed, as I say. And Division 17. All right, Esteban Duran.
Yes, sir.
Is that you, sir?
Yes, sir.
All right, sir. There's several charges here. Trafficking in fentanyl, 4 grams or more, bond $250,000. Possession of ammunition by a convicted felon, there's 3 counts of that, bond $150 each. Possession of controlled substance with intent to sell, bond $150. Resisting an officer without violence, bond $100. And possession of paraphernalia, bond $100. Now, in regard to these allegations, I don't see that you've filed the application for criminal indigent status. Can the Office of the Public Defender advise me as to whether you've got present or former representation?
Your Honor, I did not see if he was being represented by the public defender at this time, and certainly not on these immediate charges.
All right. Well, I'm still looking through all this paperwork for one. No, there is none. That's Division 22, and upon application for appointment of counsel and qualification, a lawyer can be appointed. All right, Candy Glenn.
Oh, apologies, Your Honor. If I may, it appears that Mr. Duran has been incarcerated 3 years prior and is now currently unemployed. He should certainly have indigency status. All right. Actually, sorry. Apologies, Your Honor. Okay, so you're going to have to apply for a public defender's office.
I'm out on a private attorney.
Okay, so you're going to hire private?
Yes, sir.
Okay, so disregard that phone number and just these are your bonds you have to worry about. I want to wish you good luck. Don't talk that. Oh, wait, thank you. Hold on. Okay, that, don't talk that one.
Your Honor, wait, what was the division on that case? Was the public defender appointed?
No, public defender was appointed. He plans on hiring a private.
All right, and it was sent to division?
I did not hear the division.
Your Honor, Duran Esteban Jesus. What division was that case sent to?
22.
22, thank you.
All right. That's it for the moment. Candy Glenn. Is that you, ma'am?
Yes.
All right, ma'am, you've got a new set of charges here. Possession of cocaine, bond 1,000. Possession of methamphetamine or methylene, bond 150. Possession of cannabis, bond $100. And you are released on bond at this time, and that bond would be stayed. And you want me to appoint a lawyer, correct?
Yes.
Office of the Public Defender is appointed, and this new case is Division 11.
Yes, up here, so you can bond out the other stuff, card, so you can bond out to the other county picks up.
So, when I can't bond out till the other county pick me up?
Okay, so.
Could I bond out now and then the other county pick me up? I gotta bond out first before the county pick me up?
You have a hold for Lake County.
Yeah, that's what I'm saying.
All right, so if they have bond set up for you on those charges, then you can bond out those.
So how would I know that?
I think it would be provided to you. Hold on. Apologies, records. My client apparently has a hold for Lake County. Would she be made aware of any bonds that Lake County Division posted for her? Okay, you'll be made aware as this goes on. Bond number is in. Okay, all right. You can't, all right, in that case, then you put a 0. Okay, you can't bond out yet. Don't worry about the bond that we're posting out because you can't bond out just yet. All right? Yes.
Next file is that of Sandra Gonzalez. Is that you, ma'am?
Yes, ma'am.
All right, you have two allegations here. Possession of cocaine, bond $1,000. Possession of paraphernalia, bond $100. Do you want me to appoint a lawyer for you?
Yes, sir.
The Office of the Public Defender is appointed, Division 14. All right, next file is that of Hakeem Henry. All right. All right, Joe Huerta.
Yes, sir.
All right, sir, you've got a set of charges here. Trespass on property after warning, bond $100. Possession of methamphetamine, bond $1,000. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Public Defenders appointed, Division 14. All right, next file is that of Lano Jean.
All right, you have the bonds for this. Again, down to the bond out. Double check on that. I want to wish you good luck. All right.
Your name, sir?
Leno G.
All right, so you've got a charge here, burglary of a conveyance, bond $3,500. Do you want me to appoint a lawyer for you, sir?
Yes, sir, because I
All right.
have no one to
Office
bond.
of the Public Defender, Division 14 is appointed. All right, next file is that of Jose Maderos.
Try and get in touch with the sponsor, they may have good numbers for you.
Your name, sir?
Jose Madero, sir.
All right, sir. You've got a set of charges here. Driving while license suspended with 2 prior convictions, bond $2,500. And the other case is involving possession of drug paraphernalia, bond $500. You have completed the application for criminal indigent status. You do not qualify for appointment of the Office of the Public Defender Attorney at this time. You do have, let's see, Division 15 and CRA. All right, is that it? All right, the next case is that of Stephen Steen.
Yeah.
All right, sir, a charge here of violation of probation, and there's a conflict in the pleadings here, or the paperwork. You've got 0 bond on the face sheet, and where the judge signed the warrant has a bond of $5,000. So it appears that a $5,000 bond is indicated and has been ordered. Now, sir, there's no application for public defender, so that is Division 22. The public defender is not appointed because there is no request for one. All right, the next file is that of Daniel Vasquez. Your name, sir?
Daniel Vasquez.
All right, sir. You've got a new case involving possession of cocaine, bond $1,000. Possession of paraphernalia, bond $100. You are out on bond on identical charges. Do you want me to appoint a lawyer for you, sir?
Yes.
Public defender's appointed. Now, the bond on which you were released is hereby revoked. Next case is that of Jade Childs. Is that you, ma'am?
Yes.
All right, Ms. Childs, you've got a case here involving a charge of driving under the influence. And do you want me to appoint a lawyer for you?
Yes, please.
All right. Office of the Public Defender is appointed. That's Division A.
Your Honor, my client apparently qualifies for PTR in the revised sheets. She has no priors at all. Would such a action be possible at this time?
All right, so, all right, PTR be allowed. Cyril Ferguson. Sir, you've got a case here involving a charge of driving while license suspended or revoked. Do you want me to appoint a lawyer for you?
Yes, sir.
All right, the Office of the Public Defender is hereby appointed, Division A, and the bond, if I didn't previously announce it, is $500. Oh, he does? All right, I'm advised that we have yet another case, a probation violation out of Alachua County on which there is no bond. All right.
Apologies, so it was 500 on the traffic and no bond on the BOP, right?
Yes.
Thank you. All right, we can't bond out just yet. We have that violation of probation. So call us when you know what you would like.
All right, next case is that of Kevin Acosta.
Yes, sir.
Is that you, sir? All right. Sir, two cases, it looks like. A charge of petty theft on which your bond is $250, and then an Osceola County case for a violation of probation, so you have to answer that in Osceola County. Now, your bond on this new case is $250, and in this new case, do you want me to appoint a lawyer from the Public Defender?
Yes, sir.
All right, Public Defender is appointed, and that's CRA, it says. All right, Quantavia Jackson. Your name?
Quantavia Jackson.
All right, ma'am, you've got two charges here, trespass in a dwelling. The bond is $500 as to each one. Do you want me to appoint a lawyer for you?
Yes.
All right, Public Defender is appointed, says here, Division CRA.
Your Honor, if the defense may be heard on this matter, I'm concerned over a possible clerical error. My client allegedly trespassed in one dwelling before being apprehended. Yet I see two charges here for the exact same bond amount. I'm concerned that there was as I said, I'm concerned there was an error in the filing of the charges by officers on the scene. I don't think that's. Let me see.
All right, input from the state.
One moment, Your Honor. Yes, sir, I believe that is an error. It should be one count of trespass in a dwelling. I do not, based on reading the arrest report, I do not see why two
All right,
counts were charged.
no probable cause as to count 2, then we'll say for the record, and public defender still appointed, and CRA.
Before proceeding further, Your Honor, I would like to ask, since we're down to one charge, if the state had an offer for my client, because we are on a misdemeanor pleadable.
No, Your Honor, the state does not have an offer.
If I may inquire as to records, I had additional notes for my client not qualifying for PTR. Is that still the case, or?
Yes.
Okay. Right, one moment. It is 500 at this time. Okay, that's our number cost on hand, that's the bond we're dealing with. Can you help with that? Maybe a bond can help, but I can't say for certain. All right, I want to wish you good luck.
Thank you.
All right, next file I have is that of Kelvin Mobley. Is that you, sir?
Yes, sir.
All right, sir, you've got a charge of loitering or prowling. Your bond on that case is $250 at this time. Do you want me to appoint a lawyer for you, sir?
Yes.
Public defender is appointed, Division CRA.
Apologies. If I may inquire as to the state, Mr. Mobley was only charged with loitering or prowling, and he doesn't, I have not been provided any history on Mr. Mobley. Does the state have an offer of a plea deal, or?
No, the state does not have an offer.
Very well then. Okay, so at the moment, we don't.
Judge, he has an out on bond case. He's out on bond on the case.
Oh.
Are we talking about my client or the next man?
It's 2017 CF 009346.
And you have the name of the charge?
It's possession of cocaine and tampering with physical evidence.
All right. That being the situation on this loitering case, the bond would be increased to $750 from $250 on the new case.
Are you gonna take any action on the other case?
No. right, the next file is that of Daniel Penaloza. Is that you, sir?
Yes, my name is.
All right. Mr. Penaloza, you've got a charge of possession of drug paraphernalia, bond $500. Do you want me to appoint a lawyer for you, sir?
Yes, please.
All right. Public defender is appointed. That's CRA.
Your Honor, my client qualifies for PTR, and he's been assessed as a below-average risk. Would it be possible to put him on PTR at this time?
If he qualifies for PTR, the same would be allowed and granted. All right, next file is that of Antoine Tyson. Sir, you've got 2 counts here, 2 charges of trespass in a dwelling. Bonds are $500 each, and the total is $1,000, of course. And do you want a lawyer appointed, sir?
Yes.
Public defender appointed, CRA.
Your Honor, if I may, this seems to be the exact same issue we had prior. In fact, it even involved the exact same incident. As before, the police officer seemed to have put 2 charges on the same charge. Could we have I would therefore have a PC challenge to the second trespass dwelling issue.
All right. Count 2, no PC, and the total bond is $500.
Sir?
All right, Cameron Johnson. Is that you, sir?
Yes, sir.
All right, Mr. Johnson. Sir, you've got a set of charges out of Polk County, bond $1,000, and in addition, bond $500 for a total of $1,500. And let me check these here.
Is this cadet Carter? What's his name? Johnson and Barbara Ann?
Cameron.
All right, the attachment here provides that we have an active warrant for false imprisonment, bond $1,000, and a battery, bond $500, and that's out of Polk County. So the total is the original amount, $1,500. All right, next file is that of Sean Safford.
Yes, sir. Yes, sir.
All right, sir, you've got, looks like a 2-count warrant out of Gadsden County. All right, for violation of probation. So you'll be transported there to answer those charges, sir. All right, next file is that of Carlene Cadet.
Yes.
Just a moment.
The state has an offer for this case, Your Honor.
All right.
The offer is adjudication of guilt 3 days and no return to the location.
All right, ma'am, the public defender's appointed. What says counsel?
A moment to confer with my client.
All right. What court costs on it?
And I didn't go on the property or in my apartment.
Wait, ma'am. State, in light, Mr. Barrington, in light of the fact that my client has no substantial priors, or any priors it appears, would a possible credit time served be, would be possible?
She has, history.
Huh. All right, hold on. Am I looking at the right sheet? Let's see here. I have,
It was updated.
oh, so this is
Yeah, she
income.
has 1 felony, 3 misdemeanors.
Okay, so she has history. That's very well.
County, and it's open for years.
The state is not willing to go lower than 3 days.
Okay.
All right.
That's the offer.
No, I don't need a judge's warrant. He called me when I was walking with my boyfriend. We're
Wait.
both disabled. We're both disabled. So I don't know. My mom's gone. I leave today. When we on the site fence. Mr. Jack. Does that make sense? To burn out, state?
Okay, wait, ma'am, please,
Do
ma'am, please,
anything.
ma'am, please, okay. All right. Your Honor, I apologize for the disruption. I would like to ask on behalf of my client if it would be possible to plead to the bench for a possible credit time served adjudication with no return to the scene and, of course, court costs. If not, then my client will have to choose between either the state's offer or fighting this further on.
It's my understanding, in my notes at least, I have adjudication, 1 day, credit for 1 day time served, no return, $273 in court costs payable in a year. What?
The state offer was 3 days.
3 days? Okay, my mistake then. 3 days credit for 1. So, response?
Yes, Your Honor. In light of the fact that the trespass itself was relatively benign, and while my client seems to have priors, now that I've been informed, they are not recent. I do not believe she is a flight risk, certainly. Would it be possible to consider a credit time served if a plea to the bench were submitted?
Let me look here. All right, in regard to this, upon the entry of a guilty or no contest plea, the court would adjudicate guilty and, under the facts here, sentence to 2 days credit for 1, no return, and $273 court costs.
I still gotta pay the court cost. That was.
Okay. All right. The next case then would be Barbara Johnson.
Was she gonna? Wait, did she accept the deal or?
Judge moved on to the next case.
Okay. Okay.
All right, your name, please?
Barbara Johnson.
Ms. Johnson, you've got an open container with alcoholic beverages in it, and let's see, your bond is $250. You're entitled to appointment of a lawyer. You want a lawyer appointed.
He's asking if you want a public defender.
Yes.
Public defender appointed, Division A, offer from the state.
Adjudication, credit time served. And this is for Ms. Barbara Johnson?
273.
You get out of bed.
Well, they finally changed the clock. All right, so ma'am, you understand by entering this plea, you're giving up your right to a trial.
Yes, sir.
All right, then the plea's accepted. There's a factual basis here. Adjudication of guilt. 2 days, credit for 2 days, time served. $273 court costs payable within 1 year. Say again?
Could we have Mr. Robinson reset for Yes, but could we have him reset for tomorrow?
What?
Yes.
What?
Billy Robinson. Who you got?
I got Billy Robinson and Kiara Thomas.
Kiara Thomas. Bishop Bond. Judge, what's the booking number for Kiara? 7618, 1900 7618.
Kiara Thomas,
Yeah,
she bonded.
she bonded.
Okay, good for her.
And Billy Robinson.
All right, Billy Robinson was brought in yesterday, looks like, but was mental health at that point.
He refused today.
Refused? Well,
Want
whatever.
to reset one more time?
All right, well, try again one more time.
Thank you, Your Honor.
All right, if there's nothing further, then that would conclude this afternoon's docket. Are there any objections to that?
No.
Madam Clerk doesn't object.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
All right, we're now ready to start the hearings. Nelson Figueroa?
Yes, sir.
Sir, you've got a charge here, possession of cocaine. Your bond is $1,000. Do you want me to appoint a lawyer for you, sir?
I guess so, yeah.
All right. Office of the Public Defender is appointed. That's Division 14.
Can I resolve it today?
No, it's a felony.
Felony. All right, Maggie Keene?
Yes, sir.
Ma'am, you've got a set of charges here. Possession of cocaine with intent to sell or deliver, bond $15,000. Grand theft, third degree of motor vehicle, bond $1,000. Possession of alprazolam, bond $1,000. And possession of paraphernalia, bond $500. Do you want me to appoint a lawyer for you?
Yes, sir.
All right, public defender is hereby appointed, and that is Division 20. Your name, sir?
Jason Wishes-Lennon.
All right, you've got a capias here for failure to appear on burglary and exposure cases, and there is no bond. Have you previously been appointed a lawyer?
I'm sorry, Your Honor. Is this Mr. Lennon that we're?
Yes, ma'am.
Oh,
Thank you, Your Honor.
all right, let's make sure that I understand. The name?
I believe this is Jason Aloysius Lennon.
Yes, ma'am.
Yes.
Ja- All right, we'll see if Madam Clerk can find the file. All right, Jason Lennon, right? Okay, sir, you've got a set of charges here. Possession of weapon by a convicted felon, bond $5,000. Possession of chemical agent by a convicted felon, bond $5,000. Armed trespass in a conveyance, bond $1,000. And possession of drug paraphernalia, bond $500. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Public defender is appointed, Division 10. All right, Lukash?
Yes, me.
All right, sir, you've got a failure to appear, capious. The judge set you in a no bond status. Have you previously appointed? All right, the public defender was previously appointed, Division 11. The next guy's first name is Elderly.
Mr. Parades. The next one will be 5 days, 2 days credit time served. Dormal.
AG?
Huh?
AG?
Yes. That's if it's elderly. 5 and 2.
You must be so elderly, it's not. All right, elderly Dormal?
Yes, mister.
All right, sir, you've got a case here involving an allegation of sitting or lying on sidewalks in downtown Core District. Is there an offer from the state on this?
Yes, Your Honor. It's an adjudication of guilt, 5 days Orange County Jail, 2 days credit time served, and court costs.
All right, now, let's see. Sir, you've also filed this application for a public defender. Do you want me to appoint a lawyer for you?
I don't appoint me a lawyer, but I'll take the 5 days.
All right, there's a factual basis stated here. There would be an adjudication, 5 days credit for 2, court costs of $273 payable within 1 year. All right, the next case is that of Richard Glisson.
3 days, records. When would Mr. Dormo be able to leave on the plea deal? He's in 2 days, so Saturday. Today is Thursday. Good luck, sir.
Your name, sir? Your name?
Richard Marvin Glisson.
All right, Mr. Glisson. Sir, you have a case here involving a charge of trespass on property after warning. Your bond is $500. Do you want me to appoint a lawyer for you, sir?
Yes.
All right, public defender appointed, Division A, offer from the state.
Yes, Your Honor. It's an adjudication, 7 days Orange County Jail, 2 days credit time served, no return to 105 East Robinson Street in Orlando, which is the Insight Credit Union building. Abide by all trespass warnings and court costs.
$323. All right, and for the record, what plea now is entered on this trespass case? I've been handed the plea form, so that has been signed by the accused. Plea is accepted. There would be an adjudication, 7 days Orange County Jail, credit for 2 days, time served. Court costs $323 payable within 1 year. No return to this location at 105 East Robinson Street. Court costs $323, and abide by all trespass warnings. All right, that would be everything then. Antonio Rodriguez.
Yes, sir.
Sir, you've got a Seminole County warrant for violation of probation and grand theft. So you'll be transported to Sanford to take care of the charges there. Lucius Brown. Sir, you've got a case here involving a charge of attempted burglary of a conveyance. Bond is $1,000. Do you want me to appoint a lawyer for you, sir? All right. Office of the Public Defender is appointed, Division 20.
All right. One moment. I apologize. We were missing one of the out counties. All right. There you go, sir. That's the current bond we're dealing with. That's our number. Call us when you can. Good luck.
All right. Your name, sir?
Christopher Curtis.
All right. Sir, you've got a set of charges here. Driving while license suspended or revoked, bond $500. Fleeing or eluding a law enforcement officer with lights and sirens activated. No bond at this time in regard to that charge. And I see no request for appointment of the attorney. Let's see, you've also got a case here involving possession of over 20 grams of cannabis, bond $1,000, and possession of drug-related equipment, bond $100. So there's no request for appointment of counsel here, and so that's all I can tell you right now.
Did you ask for public defenders? All right, so for the moment, I can't help you, but, you know, you're gonna wanna get in touch with the DA when you can, all right?
The fleeing and eluding, is there gonna be a bond?
I thought the bonds were called on the resisting.
The fleeing or attempting to elude a law enforcement officer with lights and sirens active is the one that states no bond.
And Your Honor, if the state may be heard as to bond on that count,
All right?
the state would recommend to the court a bond of $2,500.
All right, instead of no bond, count 2 on this case would be $2,500, and the bond on the other case remains the same.
He qualifies for PTR.
And Your Honor, the state would oppose pretrial release as one of these charges is fleeing and attempting to elude law
Well,
enforcement.
I would agree, and that would be ordered. And let's see, we've got Division 20 in regard to the Dwellis and the fleeing, and Division 17 on the burglary, etc. Wait a minute, wait. Yes, that's, I misstated that. All right. Then possession of marijuana bond 1,000 and equipment bond 100. Divisions 20 and both are Division 20. All right, next case is that of Damian Guthrie. Is that you, sir?
Yes, sir.
Sir, you've got a case here involving 2 charges: burglary of a dwelling, bond $5,000, grand theft of more than $100 from a dwelling or curtilage, bond $1,000. Do you want me to appoint a lawyer for you, sir?
Yes, sir, please.
Office of the Public Defender is appointed, Division 17.
Nothing to do right now, sir. Don't worry about it. That's
All right, Antoinette Jackson,
Yes, sir.
is that you, ma'am?
Yes, sir.
All right, Miss Jackson. Ma'am, you've got a charge here, possession of amphetamine. Bond is $1,000. You want me to appoint a lawyer for you?
Yes, sir. But I was told I could try for a pretrial release.
All right. My question was simply, do you want me to appoint a lawyer, yes or no?
Yes, sir.
Okay.
I'm sorry.
Public Defender appointed, Division 16. All right, your name, please?
Clavy Jones.
Sir, you've got a set of charges here. Carrying concealed firearm, bond $150. Possession of a firearm by a convicted felon, bond $150. Possession of ammunition by a convicted felon, bond $5,000. There's no request for a appointment of a lawyer. That's Division 20. All right, next case is that Igor Milov.
Correct.
All right, sir, you've got, looks like 3 cases here. A failure to appear on a grand theft 3rd degree, no bond, Division 22. Failure to appear on a trespass, no bond, and a failure to appear on resisting an officer with violence, no bond. Do you want me to appoint a lawyer for you, sir?
Yes.
All right, Division 22 on failure to appear on the grand theft, 3rd degree. That's Division 22. Then Division 15 on trespass case, and Division 22 once again on the resisting with violence. Michael Parks. All right. Carlos Paris.
Yes, sir.
Sir, you've got a charge here, retail theft, more than $300. Bond is $1,000. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Office of the Public Defenders appointed, Division 12. All right, next file is that of Eric Quintana Rivera.
Yes, sir.
All right, sir, a set of charges here. Fleeing or attempting to elude a law enforcement officer with lights and sirens, bond $2,500. Possession of heroin, bond $1,000. Possession of paraphernalia, bond $500. Resisting an officer without violence, bond $1,000. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Oh, there's another case here, resisting an officer without violence, bond $500. Public defender appointed, Division 12 on the multiple charges and A on the resisting without. All right, Romaine Davinsky.
Yes, sir.
All right, sir, a set of charges apparently. Carrying a concealed weapon by a convicted felon. Possession of cocaine with intent to sell or deliver with a weapon. And on the first charge there, concealed weapon, no bond. cocaine case, no bond. Possession of cannabis with intent to sell or deliver with a weapon, no bond. And possession of cannabis more than 20 grams with a weapon, no bond. And possession of cocaine with a weapon, no bond. Possession of ammunition by a convicted felon, bond $5,000. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
All right. Public defender is appointed, you qualify. Division 6 on concealed weapon by a convicted felon. Division 10, possession of cocaine with intent to sell with a weapon. Division 15, possession of cannabis with intent to sell with a weapon. And Division 22, possession of cannabis more than 20 grams with a weapon, no bond. And Division 16 with the charge of possession of cocaine with a weapon, no bond. And then lastly, possession of ammunition by a convicted felon, bond $5,000. Now, you have several different divisions. Division 6, 10, 15, 22, and 16, and 19.
Your Honor, may the state be heard as to bond on the matters that are listed as no bond, Your Honor?
Yes.
In 2019 CF 3594AO, possession of cannabis greater than 20 grams with a weapon, the state would recommend a bond of $5,000.
All right, so ordered.
And in 2019 CF 3597AO, carrying a concealed weapon by a convicted felon, the state would recommend a bond of $5,000.
So ordered.
And 2019 CF 3593AO, possession of cocaine with a weapon, the state would recommend a bond of $7,500.
Now, did you say 3595?
3500.
Okay.
Yes, 3593, Your Honor.
Okay. Let me get that.
And in 3595, possession of cannabis with intent to sell and deliver with a weapon, the state again recommends a bond of $7,500.
All right.
And in 3596, possession of cocaine with intent to sell and deliver with a weapon. In this possession of cocaine, the state would recommend a bond of $10,000.
Okay. So ordered.
And the final case already had a bond set, Your Honor.
All right. And the public defender, again, has been appointed. All right, next case is that of Virgil Stevens.
Yes, sir.
Sir, you've got a case here involving failure to appear on driving while license suspended, possession of paraphernalia, and at this time you're in a no bond status, and I have no application for criminal indigent status, so if you may well have a public defender already appointed, but one is, yes, you do. That's Division 15. Your name, sir?
Jose Torna.
All right, Mr. Torna. Sir, you've got 2 counts here. No bond on failure to appear on count 1, delivery of heroin, and count 2, delivery of cannabis. There's no application for criminal indigent status. You were probably already appointed a lawyer. Okay, the public defender already represents you, Division 12.
Wait, hold on. You will get the name get to the office on that. I don't have the information at the moment. He's not set in stone right now. But I want to wish you good luck. Right, call us when you can.
All right, your name, sir?
Edward Wilson.
Mr. Wilson, sir, you've got a set of charges here. Purchase of heroin, bond $15,000. Possession of heroin, bond $150. Attempted destruction of evidence, bond $100. Possession of drug paraphernalia, bond $100. Fleeing, attempting to elude a police officer, no bond at the moment. Resisting an officer without violence, bond $100. Do you want me to appoint a lawyer for you, sir?
Yes, Your Honor.
All right. And is there any input from the Office of the State at this time on the fleeing case?
Yes, Your Honor. The state would recommend a subsidiary bond on count 5 at $150.
All right. That seems reasonable. Bond $150 on count 5, fleeing. And, sir, let's see. Did I already ask about a lawyer?
Yes.
Okay, public defenders appointed, Division 22.
Your Honor, just to double check, the first count was 15,000?
Correct. All right, Nicholas Brown.
Yes, sir.
All right, Mr. Brown, you've got a case here involving a charge of panhandling. Your bond is $500. Do you want me to appoint a lawyer for you, sir?
Yes, please.
Public defender appointed, offer from the state?
Yes, Your Honor. It's an adjudication of guilt, 4 days, Orange County Jail, 2 days credit time served, and court costs.
That's how much? All right, sir, you don't have to accept that offer. You may, if you want.
I accept. My client would like to accept the state's offer and enter a plea of no contest.
All right, plea is accepted. Adjudication, 4 days, Orange County Jail, credit for two, $273 court costs payable within 1 year.
Thank you. One moment, we quickly sign, make sure everything's in order. Slow writer. Second. That's it. Good luck, sir.
All right, next file is that of Lloyd Salter. Is that you, sir?
Yes, sir.
Sir, you've got a charge of camping, bond $250. You want me to appoint a lawyer?
Yes.
Public defender appointed, offer from the state.
Yes, Your Honor. It's an adjudication of guilt, 5 days Orange County Jail, 2 days credit time served, and court costs.
273. All right, sir, please accept it. Adjudication of guilt, 5 days credit for two, court costs $273, payable within 1 year. Thank you. All right, Michael Springs. Sir, you've got a charge of camping. You want me to appoint a lawyer?
If I need one.
You qualify for the appointment of the public
Okay,
defender. Do you want that appointment?
Yes, I can.
Public defender's appointed, offer from the state.
It's an adjudication of guilt, 5 days Orange County Jail, 2 days credit time served, and court costs.
Crazy. But I ain't got no choice but to take it. I don't understand what this is supposed to teach me.
All right, in regard to this case, then there would be an adjudication upon the written receipt of the plea form. 5 days credit for two, court costs $273, payable within a year. Your name, please.
Yaritza Cruz.
All right, Ms. Cruz, you've got a set of charges here. Petty theft, bond $250, and then you've got an Osceola County case, a violation of probation, and you're in a no bond status as to that. Now, in regard to this Orange County case, do you want me to appoint a lawyer for you?
Yes.
Public defender appointed, Division A. Now, is there any offer from the state on the Orange County case?
As she's on probation for a theft case, no, Your Honor.
All right. Public defender appointed.
Your Honor, if the defense may be heard.
All right.
My client is going to be dealing with a probation case, I think connected to this matter in another county, Osceola. Would it be possible to release her ROR so she can go to Osceola and deal with that matter before that judge?
All right. State's response?
Your Honor, the state would object. She was on probation for a theft case, has now allegedly committed another theft case, the state would object to release ROR.
All right, let me look here. All right, there is a, on the Osceola County case, that is a grand theft case. The defense request would be denied in that regard. All right, next file is that of Geneva Dixon. Is that you, ma'am?
Yes.
All right. Ma'am, you've got a set of charges: petty theft with prior convictions, bond $500, and possession of cannabis, bond $100. Do you want me to appoint a lawyer for you on these cases? Did you answer?
I can't hear you.
Do you want me to appoint a lawyer for you?
A lawyer? Yeah. Yes.
All right, Office of the Public Defender is appointed. That's Division A.
If I may ask, records, my client does not qualify for PTR, but the reason is additional notes. Was there a more compiled reason available on your end for the qualification for PTR for my client at this time?
Yes, she refused to provide emergency contact.
Yeah. I'm not even gonna go through that.
So these are the bonds we're currently dealing with. Please call us when you can. I want to wish you good luck.
All right, Austin Glatt.
Yes.
Sir, you've got a new charge here, petty theft. You're out on bond on a burglary of an occupied structure, etc. The bond on which you're released is stayed. The bond on your new case of petty theft is increased to $1,000 from $500. Do you want me to appoint a lawyer for you, sir?
Yes, please.
All right. Public Defender appointed, Division A.
Your last bond is still good. All you have to worry about is this bond. Okay, so you don't want to talk about bonds, I don't think the numbers actually changed much from what it was 500. So, but again, I want to wish you good luck, okay? All right, good luck.
All right, your name, please?
Ichala
Full name.
Ibukunlua Ayokunumi.
All right. Ma'am, you've got a trespass charge here. You did not, and you're out on bond on trespassing in a structure or conveyance. Now, there's no request for a lawyer. So in regard to the new case, since you're out on bond on the old case, that ROR would be extended on that old case. And the new case, the bond would be $1,000 instead of No, strike that. It would remain at $500. And no application for criminal indigent status was filed. So at this time, no lawyer appointed.
Yeah, excuse me,
Right now, yes. Did you want a public defender or something?
no.
Okay.
I mean, my lord, I mean, really, I should not be on the street. You know, I think I do have more than enough money to have a house, to stay inside of the house. I think they're keeping me outside intentionally. I've been outside for 6 years, and it should not be. I can't even get any employment. I'm entitled to, I have every right to have employment. I have every right to have to be inside the house with my children. Yesterday, I was at the tax office, no, I mean, the tax thingy, she's supposed to actually return my money.
Oh. Your name, please?
Wesley Crochet.
All right, I want to make sure I have the right paperwork here. George Montoya Moran. Is that correct, sir?
No, sir.
I got a DOP out of state. I mean,
I'm sorry, sir. Did I mix up?
All right, sir, your name, please?
George Montoya.
All right, sir. You've got a set of charges here. Assault on an officer or firefighter or EMT, bond $500. Resisting an officer without violence, bond $100. Sir, do you want me to appoint a lawyer for you?
Yes, please.
Office of the Public Defender is appointed, Division A. All right, next file is that of Jamiah Zelaya. Your name, please?
Jamiah Zelaya.
All right, ma'am, you've got a charge of trespass after warning. Do you want me to appoint a lawyer for you?
Yes.
Public defender appointed. Offer from the state?
Yes, Your Honor. It being adjudication of guilt, 5 days Orange County Jail, 2 days credit time served, no return to 4117 South Cimarron Boulevard, which is the Avalon condominiums, and abide by all trespass warnings.
Apologies. What was the days to be served?
5
Okay.
with
thank
2.
you. Thank you. My client would like to accept the state's offer and enter a plea of no contest.
All right, there's a factual basis here. The plea would be accepted, adjudication of guilt, 5 days credit for 2, no return to this location at 4117 South Cimarron Boulevard, Orange County, and abide by all trespass warnings.
And Your Honor, the state has one more condition, and that would be no contact with the victim Miriam Palacio, the owner of the property.
All right, so ordered.
Jamiah Zalia.
I can't hear.
Jamiah Zalia.
All right, next file I have is that of Severino Castillo.
He's not, Your Honor.
All right. Reset. Yeah. All right, Wesley Croce? Wesley Jr. Croce, if I pronounce that correctly.
Crochet, sir.
All right, sir, you've got a Hillsborough County warrant.
Yes, sir.
For violation of probation, it looks like. So you'll be transported to Tampa to take care of the charges there, sir.
Okay.
Thank you. Sean Rhines. Say again? All right. Ooh, $70,000. Alicia Rivers. Is that you, ma'am? Yes. Okay. Ms. Rivers, you've got a Seminole County warrant. You're in a no bond status in regard to that. So you'll be transported to Sanford to take care of the charges there, ma'am. All right, the next file I have is that of Mario Aponte. All right, sir, you've got a charge of aggravated assault. Your bond is $2,500 with condition no victim contact. Do you want me to appoint a lawyer for you, sir?
Yes, sir, please.
Public defender is appointed, and says here Division EAB. 16. 16? No. No action taken on the bond on which he's released.
A moment, you're good on this last one, so all I have to worry about is this bond, okay? Call us when you can, it's an online. I want to wish you good luck, sir.
Next file I have is that of Paul Clark. All right, yesterday was mental health also. I'm appointing the Office of the Public Defender to represent Mr. Clark. It was an open container.
You want to keep his bond, or you want to reset, or?
Reset. All right, Candy Glenn.
Yes.
Ma'am, you've got a charge here, introduction of contraband into county facility, bond $1,000 at this time. Do you want me to appoint a lawyer for you?
Yes.
All right, Office of the Public Defender is hereby appointed. And I assume there's no offer from the state?
No, Your Honor, that is a felony matter.
All right, Division 20.
Just,
Then have Wayne Malier.
Your Honor, just to seek clarification on my client, Ms. Glenn, we're just here for the 3556AO case, the introduction to contraband, right?
Yes. Yes, sir.
Okay, one moment. Let me give her the paperwork. Apologies. Okay, ma'am, that's the bond for this case. Call it. Yeah, I want to wish you good luck.
All right, Wayne Malier.
Yes, he is. He don't know where you're at.
All right, sir, your name, please.
I don't have a name.
You don't have a name.
No, I don't.
All right. Huh.
So why am I here?
Well, I've got a Wayne Malier case. Input from counsel in regard to this unusual situation with a no-name defendant.
Your Honor, as Mr. Malier, Mr. AKA No Name, has been brought out under Wayne Malier, and I believe that possibly prints have confirmed his identity.
Well, in an abundance of caution, what I'm going to do, let's see, we got heroin, count one, $1,000 bond, fentanyl, bond 150. I'm going to appoint the Office of the Public Defender to represent this individual with no name.
Well, how about I represent the,
All right, the bonds in regard to 2019-2264 and 2018-17860 are revoked.
Oh, sorry, one moment.
I'm not a party to the transactions. That name is private property. It belongs to me. I'm hereby seizing that name. You want to use it, get my express permission.
I have the paperwork. Okay.
And I apologize, Your Honor, on Mr. Malier, were the bonds stayed in 3502?
Yes.
Thank you.
Oh, okay. All right, the next file I have is that of Justin Upton. Your name, sir?
Justin Kenneth Upton.
Mr. Upton, sir, you've got a charge here, a retail theft, more than $300. Bond is $1,000 at this time. Sir, do you want me to appoint a lawyer for you?
Yes, sir.
All right, Office of the Public Defender is hereby appointed, and for a division number on this new case, it has TWY 14. Oh.
Apologies, Your Honor. A moment to prepare my paperwork and possibly
Is-
prepare my paperwork. One moment.
All right, now for clarification here, what is the name of the individual before the court at this time?
Luis Arturo Benavides Hernández. Luis Arturo Benavides Hernández.
Oh, oh. All right.
Apologies, Your Honor. We are here today on a motion for release on own recognizance for my client today, Luis Arturo Benavides. I would like to swear in my client to, my client is currently unable to pay his bond and has been found indigent by the court. He was assigned a public defender because of that. I would like to swear him in to ask him some questions so that the court may be enlightened to his current predicament.
Please raise your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
All right.
Your Honor, before we proceed, may the state be heard. The state has no objection to this motion, Your Honor.
All right. And any recommendation as to, ROR, right?
Yes, Your Honor. It would be, the
All
state
right.
would ask for an ROR with, just an ROR, Your Honor.
All
This
right.
was a resisting without violence.
Then, so ordered.
Okay, you're good. Apologies, Your Honor. If I may confer briefly with state, apologies. Yes. Your Honor, with respect to my current client, Miss Caitlin Deanne Murray, the public defender would at this time like to withdraw her motion pending further review of her case.
All right.
He wants to withdraw the motion.
Motion withdrawn. Your name, please?
Aaron Torres.
All right, state have any input?
Your Honor, if the state may just ask pretrial services if there are any prior failures to appear and what the conviction history is.
We have no, failure to appear, no misdemeanors, no felonies, no Florida, conviction history. He have arrest history, petty theft, trespass, out of state convictions. He have burglary, 3 times 3, misdemeanor larceny, possession of heroin, possession of Schedule 1 heroin, breaking it, entering. Out of state arrest, he have trafficking, DV, particular order violation times 3, possession of stolen motor vehicle, obtained property, false pretense.
At this time, Your Honor, the state would ask that defense proceed with their hearing.
Certainly. Your Honor, we are here today for my client, Mr. Efrain Torres, seeking a non-monetary release. Simply put, my client has been found indigent, which is why the public the public defender's services were rendered to him. I would like to swear him in so that he can help enlighten the court as to his current predicament, and of course to assist in his plea.
All right.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right. Mr. Torres, I have to ask, are you able to pay the premiums on your current bond?
Not at the moment, no.
All right, and Mr. Torres, do you have any source of income at this time?
No, not at the moment.
Okay. And do you have anything you think you can sell? Anything you can pawn off?
No, no, sir.
All right. I would like judicial notice to be taken that the court has accepted an affidavit of insolvency in this case. The accused is therefore presumed to be indigent and without financial resources. So if such notice may be noted, I would continue in my questioning of my client. And Mr. Torres, do you have family in the area of Orlando?
Yes, I do. I have a grandmother and a father that lives in Buffalo.
All right. Did you reach out to your family in the area to ask you for assistance with the bond?
I didn't bother because they're both on fixed incomes, collect disability.
Okay. Now, sir, have you ever gotten into any trouble in Florida before this case came up?
No, sir.
All right. Now, Mr. Torres, I need to ask a couple questions. If you're released on or without having to pay bond, would you swear to attend all future court dates?
Yes, most definitely.
All right. Would you have a place to stay in the local area?
Yes, I do.
All right. And would you appear for, all right, do you have a means by which to get to every single court date?
Yes, I do.
What are those means, Mr. Torres?
I plan on working at a temp agency as soon as I get out of here, raising some type of funds and being able to take the bus, the transit system here in Orlando.
All right, now, Mr. Torres, I need to ask you, what are you going to do if you are released without having to pay bond?
I will seek employment at a temp agency, returning to society, being as productive a member as I possibly can, and attending all my future court dates, and just getting this behind me, paying fines, fees, and spending time with my grandmother. That's she's getting up in age, and that's basically it, getting this behind me.
All right. I have concluded the questioning of my client at this time, Your Honor. If the state had any questions?
Yes, the state does. Mr. Torres, good morning.
Good morning, ma'am.
Mr. Torres, you said, in response to your counsel's questions, you said that at this moment, you cannot afford bond.
No, ma'am, I can't. I don't
Okay.
have any money.
You qualified it with not at this moment. Is that correct?
Yes, ma'am.
Have you called a bondsman?
No, I haven't bothered because I don't have any money to pay one.
Okay, so you have not bothered to call a bondsman. What is the amount of your bond?
$500.
And Mr. Torres, what is your understanding of what you would have to come up with for that bond?
I'm uncertain of that.
Okay.
From what I hear, 10%, but you have to have a co-signer and,
Okay. All right. And Mr. Torres, you did not reach out to any bondsman, correct?
no, ma'am.
And you said that you did not reach out to your family. I believe you said your grandmother, correct?
My father.
And
Yes,
your
ma'am.
father, correct?
Yes, ma'am.
And you said that was because they're both on fixed incomes.
Yes, they
Is
both
that
collect
correct?
disability.
But you did not reach out and ask your grandmother if she could assist you. Is that correct?
No, ma'am, just for the simple fact that she's like up in her
And
age, she's
I
old.
appreciate the explanation.
Yes, ma'am.
But is it correct that you did not reach out to your grandmother?
And partly because of that, I can't remember the phone number to call her.
Okay. And is it correct that you did not reach out to your father?
That's correct as well.
Okay. So you did not reach out to the bondsman, your grandmother, or your father?
No, ma'am.
And you're going to reside with your grandmother and your grandfather, and your father
Yes, ma'am.
in Orlando here?
Yes, ma'am.
And your counsel's motion states that you are self-employed in the vinyl siding business,
Yes, ma'am.
and that you intend on continuing that employment if you're released.
If possible, yes, ma'am.
Okay. And when you said that you have no means of income at this moment, were you working before you were arrested?
Yes and no. I was doing vinyl siding when there was work.
Okay. When is the last time that you had a siding job?
Less than 3 months ago.
About 3 months ago?
Yes, ma'am.
And do you get paid per job, per hour? How do you get paid?
Weekly.
You get paid weekly?
Yes, ma'am.
And since you're self-employed, is that you paying yourself?
No, I mean, I was working with the crew, but it was more or less under the table when I was working more recently. So I just consider that self-employed.
Okay. Okay, so you were actually working for a company?
Yeah.
Okay.
As of recently.
But you got paid weekly when there were jobs?
Yes, ma'am.
Okay. I have no further questions. Thank you, sir.
All right, anything further from defense?
No further questions for my client, only arguments. Your Honor, my client came to Florida, as the facts will show, to get a fresh start. He came here and got into some trouble. I believe the case number is 2019 MM00136680. However, he has been found indigent by the court. He is unable to pay. Keeping him here when he is, of course, willing to attend all future court dates is, I think, against the pursuit of justice. Any person, as per Rule 3.131A, any person charged with a crime which is neither a capital offense nor a crime punishable life imprisonment. Apologies, one moment. Okay, so the imposition of a money bond on an individual already declared by the court indigent is, I find, unreasonable. Well, my client is already is willing to attend all future court dates. He has connections to the community, and he is, of course, willing, and he is going to become a more productive citizen if allowed out to work. Simply put, I would like to end my argument by saying that I believe it would be in the best interest of the community if my client were allowed to reintegrate as court date was pending.
State.
Yes, Your Honor. This, number one, is a victim crime, and there are damages to a unrelated, independent victim in this matter. And that victim did not have an opportunity to be present today to provide their input because this matter went on the docket yesterday afternoon and the state was not able to contact the victim to get them here today. Having said that, there has been no testimony put on the record to show that there has been a change in circumstances since the time that the bond was set in this matter. And also, based on Mr. Torres's testimony, he has not made any attempts to see what his portion of the bond would be. He has made no attempts to see if he can get assistance in obtaining a bond. The motion states that he is self-employed. His testimony states that he does work in vinyl siding, and he testified that he will seek employment on a temporary basis once released. The state would ask the court to deny his motion in part and modify his bond according to what the state is seeing. And if I may just make certain that I'm looking at the correct minutes here, Your Honor. Okay. The state would have no objection to a modification in the bond. However, because there has been no change in circumstances, he has made no attempts to see if he can come up with the $500 bond. The state would ask the court to deny the motion in part and modify his bond to $250 with a standing order of no return to the scene of the crime.
All right, defense.
Here. Defense would argue only that the facts of the case show that the incident for which he was brought in Florida, there were mitigating circumstances. Apparently, one of the involved persons attempted to falsely imprison his vehicle, which thus led to the escalation, which resulted in the resulting damage, Your Honor. If my client cannot be allowed out ROR, however, considering these mitigating circumstances, would a further reduction of the bond be possible?
All right. Well, the court, under the circumstances here presented, would modify the bond to $200 with a condition, no return to the location of the alleged offense.
And Your Honor, if the state may, that would be the area of Belvedere Road and Lynbrook Road in Bithlo, Florida.
All right. All right, next file I have is that of Leroy Royal IV, case, don't have it. Oh, here we are. Case ending number 419.
Your Honor, this time the state's going to need a moment just to switch over to that docket, if I may.
All right.
Thank you.
You're going to be here tomorrow. You're my favorite. Gee whiz, that's not nice.
It's gone. Don't see mine. I apologize, Your Honor. I'm having a little bit of a technical difficulty here. Thank you, Your Honor. The state's ready.
All right. So, Leroy Royal. All right, if council would please announce their names for the record.
Good morning. Edith Bush for the Office of the State Attorney, second session.
Fernando Pardes of the Office of the Public Defender.
All right. Now, the first file I have is that of Billy Robinson. Is that you, sir?
Yes, sir.
All right, sir. You've got a case here involving a charge of trespass on property after warning. You want me to appoint a lawyer for you, sir?
Yeah, I'd like the public defender.
Public defenders are lawyers.
Oh, yes, sir.
The Office of the Public Defender is hereby appointed. An offer from the state.
Yes, Your Honor. The offer is an adjudication of guilt, 10 days Orange County Jail, 3 days credit time served, no return to the scene, which is the Wawa at 4100 East Colonial Drive, abide by all trespass warnings, and court costs.
My client would like to accept the state's offer and enter a plea of no contest.
All right, there's a factual basis stated here. So the plea would be accepted by the court. There would be an adjudication, 10 days, credit for 3 days, time served in the Orange County Jail, no return to this location at 4100 East Colonial Drive, the Wawa, as I understand it, and abide by all trespass warnings, if any, and court costs $323 payable within 1 year.
Good luck, sir.
So I'll get out 10 days?
7.
All right, Danny Dutty?
Doty, sir.
All right, sir, you've got a case here involving trespass after warning in a conveyance. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Public defenders appointed. CRA Division, offer from the state.
Yes, Your Honor. It's an adjudication of guilt, 7 days Orange County Jail, 4 days credit time served. No return to the Burlington Coat Factory at 8204 South Orange Blossom Trail, and abide by all trespass warnings and court costs.
What would the court cost be?
I'm not taking that.
Sorry, hold on, if I may. If the defense may be heard, Mr. Doughty doesn't seem to have a very extensive criminal history. Would a possible credit time served be possible considering his,
I just had surgery.
considering that he is in a currently a less than optimal condition to be in jail under?
All right, I note that this case was reset because the accused was in the hospital yesterday, it would seem. No, the 11th.
On Monday, Your Honor.
Yes. So,
And, Your Honor, may the state be heard as to the rationale behind the state's.
Yes.
The state's offer, which was formulated on the 11th, is based not only on the facts in the case, but also on his Florida conviction history, which includes trespass ×4, and some of those trespasses were at the same Wawa. Disorderly intox, petty theft ×3, and various violations of ordinances. He also has an extensive out-of-state conviction history as well. And that is what factored into the 7 days that the state is offering at this time.
And if the defense may be heard, whilst I admit that Mr. Doughty does have a history, I did not say he did not. I would also say that he has just gotten out of surgery. He's a former military veteran. I don't think the cause of justice would be furthered by keeping my client in jail for 3 more days, considering his condition.
I was beat up and robbed. I had to sit down.
Apologies. All right. It would be 3 more days or about 3 more days. All right. I know you're in a bad state, so.
all right, and sir?
Yes,
I would
sir.
inquire as to, is that a bandage on your chest or a name tag?
I was
Okay.
beat
All
up and
right.
robbed, sir. I got a bandage on my back.
Okay. All right.
I would, at this point, request clarification from the bench. Would a possible plea to the bench result in a credit time served for my client? I'm only asking because of his current condition, not on any merits of the case.
All right, in the event a plea of guilty or no contest is entered, there would be an adjudication and a total of 5 days, credit for 4 days, time served, no return to this location at 8204 South Orange Blossom Trail. Abide by all trespass warnings, and court costs payable $323 within a period of 1 year.
I'm blind. Right here. on today, right, man? Okay.
Okay, sir, I need to ask, are you on probation anywhere?
No.
Okay, good, then you're safe.
The next file I have is that of Kern Blount. Is that you, sir?
Yes, sir.
All right, sir. You have a new case involving grand theft third degree of a motor vehicle. Your bond was set at $2,500. You are presently out on bond on drug charges, 2 drug charges. That bond at this time would be revoked. Do you want me to appoint a lawyer for you, sir?
Yes.
Public defender appointed, Division 12 on the new case.
But your last bond has been revoked, sir. Okay, I'll leave the public defender transfer, and I want to wish you good, right?
All right, Garen Collins. Is that you, sir?
Yes, yes.
All right, Mr. Collins, you've got a failure to appear capious, 2 counts, attempted burglary of a conveyance, resisting an officer without violence. The judge in that case set you in a no bond status. There's no financial affidavit filed. So at this time, no attorney would be appointed. If there's one already appointed, that would stand, and that's Division 12.
You already have a public defender assigned to your case, that's good. One moment, let me give you our number, forgot it. Okay, wait, take this, good luck.
All right, next file is that of Harold Horn.
He's in the hospital, Your Honor.
All right, reset. All right, next cases are Timothy Hogue.
Yes, sir.
All right, sir, you've got a new case here involving grand theft third degree of a motor vehicle. Bond on that case is $1,000, and then burglary of an occupied structure. No bond as to that case. The bond on which you're released, which is another grand theft third degree of a motor vehicle, is revoked. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
All right, and I'm appointing the public defender, but you also have a case of possession of methamphetamine, bond $1,000. Public defender is appointed, and we have Division 19 on the grand theft case and 15 on the drug case.
And Your Honor, may the state be heard as to count 2 in 2019 CF 3618AO as to bond.
All right, hold on just a second. All right, say again as far as the request.
The state would like to be heard as to bond as to count 2, burglary of an occupied structure.
All right,
The state would recommend a bond of $7,500 and request the court order no return to the scene.
all right, so ordered as to that, so you could be released on posting the bond, sir, and no return.
Your Honor, if I may, if the defense may inquire, would the judge be willing to allow the out on bond to stand with the understanding that one of the other charges could be doubled?
All right, state's response to that request?
Your Honor, as this is a similar type crime as the one that he was out on bond on, the state would ask the court to stay the revocation.
All right, the court's prior decision on that case looks like the grand theft third degree on which he's already released, that request would be denied. That bond would be revoked.
Your Honor. All right, okay. You're currently having your last honor vote. You can't bond out yet. Call our number when you call this.
All right, next file is that of Terry Lee Hudson. Is that you, sir?
Yes, sir.
Sir, you have a set of charges here. Burglary of an occupied structure, bond $5,000. Petty theft, bond $100. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
Public Defenders appointed, Division 17. All right, your name, please?
Amanda Lynn Kitteman.
All right, ma'am, you've got a new set of charges. Carjacking, bond is no bond at this time. Aggravated battery with a deadly weapon, bond $150. Grand theft third degree of a motor vehicle, bond $150. Grand theft third degree more than $300, less than $5,000, bond $150. There's a factual basis, and you're out on a couple of bonds here, dealing in stolen property, scheme to defraud, and possession of cocaine, etc. And those bonds, each of them would be revoked. Now, do you want me to appoint a lawyer for you?
Yes, please.
Well, let's see. Yes, here it is. Public Defender is hereby appointed, and looks like Division 12 in each of these new cases.
Your Honor, did we go over the cases of 3620AO and 3236AO for my client's bond status?
All right, let me look here. All right, what was the case number of that?
The first one is 2019 CF 3236. The carjacking was the bond stayed at 0.
Yes.
All right. Got it. 0. All right. That will be it for the moment.
Yes, it was. I thought I did. All right. What I think is a repeat here. Grand theft, third degree of a motor vehicle, new case, allegedly committed today. Grand theft, third degree of motor vehicle, bond 1,000. And then possession of methamphetamine, new case today, and that is $1,000. And the Office of the Public Defender is appointed. Next file I have is that of Sharon Mack. All right. Joanna Murphy. Jonathan Nieves de Jesus?
Yes.
All right, sir. A case involving an allegation of possession of cocaine, and the bond on that is $1,000. Now, there was a capias issued, no bond, for failure to appear in court. Now, do you want me to appoint a lawyer for you?
Yes.
All right, public defenders appointed, Division 10. And 81 on the FTA if none has been appointed. All right, Alberto Rodriguez.
Yes.
That's you, sir. Sir, you've got a set of charges here. Armed robbery with a weapon, bond $10,000. Criminal mischief, bond $150. Now, there would be a condition also added to the robbery allegation, $10,000, and possess no weapons or firearms. And, sir, do you want me to appoint a lawyer for you?
Yes.
Public defender is appointed, and that's Division 14.
And Your Honor, the state would also request a no return to the scene, the eye smoke outlet, and no contact with any witnesses or victim.
All right, that would seemingly be appropriate. That's ordered also. All right, next file is that of Jamiah Smith. Is that you, ma'am?
Yes.
All right, ma'am, you've got a charge of possession of cocaine. Bond is $1,000. Do you want me to appoint a lawyer for you?
Yes.
Public defender is appointed, Division 11. All right, next file is that of Terrell Green. All right. Then the next file is that of Kelvin Aguilar. Is that you, sir?
Yes, sir.
All right, sir, you are released on a petty theft bond. That bond is stayed. You have a new case involving a charge of trespass on property after warning. Do you want me to appoint a lawyer for you on that new case?
Yes, sir.
Public defenders appointed, CRA. Is there an offer from the state on the new case?
Yes, Your Honor. It'd be an adjudication of guilt, 10 days, and 2 days credit time served, no return to the Wawa at 7030 South Orange Blossom Trail. Abide by all trespass warnings and court costs.
If defense may inquire of the state, I know my.
Oh, excuse me. I didn't go read far enough here. Mr. Aguilar does not qualify for appointment of the office of the public defender. So that announcement, if made, is hereby revoked. All right, so sir, you can, Mr. Aguilar, you can enter a guilty plea to that new charge. If you do, you'd be adjudicated guilty, sentenced to 10 days with credit for 2 days time served, so you'd have 8 more days. No return to the Wawa there at 7030 South Orange Blossom Trail, and court costs $273 payable within 1 year, and abide by all trespass warnings if any others exist. So, do you want to accept that?
Yes, sir.
All right. There is a factual basis stated here, so the plea would be accepted on the new case. There would be an adjudication, 10 days, credit for 2 days, time served, no return to this location as previously described, abide by all trespass warnings, pay court costs in the amount of $273 within 1 year.
Thank you.
Yes, sir. All right, next case is that of Tashia McLean.
Bonded.
All right. Deron Michael?
Yes, sir.
All right, sir, you've got an Osceola County warrant, and your bonds total $15,500. You can post bond here. If not, you'll be transported to Kissimmee to answer to the charges there. All right, and the next file I have is that of Luis Valero. All right. All right, anything else from council?
Nothing further from the state, Your Honor.
Nothing further from the defense, Your Honor.
All right, then we're in recess subject to call, actually.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.